Has he completed his sentence? Morency?
He claims he has.
Okay, we're finally ready. Mr. Thompson, are we ready with Ms. Sheldon's case?
Yes, Ms. Sheldon is here. Thank you.
Go on the record in People versus Sheldon. This is District Court case number 2517994. Presiding over this case on behalf of Burmeister, if I could have counsel for your appearances on.
Wilson Broad on behalf of People, Your Honor, as special prosecutor.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Andrew W. Sheldon.
Mr. Thompson, how do we want to proceed today?
We wanted to proceed to jury trial, Your Honor. The prosecutor did make two separate offers, either to a deferral or to a disturbing of peace. Conferred with my client. She's electing to proceed to jury trial.
Okay. Mr. Bratt, how much time do you need to be ready for trial in this case?
In terms of the length of the trial, Your Honor?
Just
Or
for
just-
preparation between now and then.
Not long.
Okay, as soon as I could get a date.
Yeah.
And how many days do you think we'll need?
This is probably a half day at best.
Yeah, I mean, we might spill over the lunch hour, but I'd be confident we'd be done less than a full day. I'm planning on calling, 0 or 1 witnesses, not planning on filing any pretrial motions.
Okay, and Mr. Thompson, is there a particular period of time you need to be?
No.
Okay, so I'm gonna just put it on for a 1-day jury trial at the court's next available date. Court will send out notice of the date and time of the trial. I won't set any dates prior to the trial, so that'll be our next date. So Ms. Sheldon, that'll be your next appearance in court is the day of trial. You'll need to be here by 8:30 and ready to go. It's important that you stay in touch with your attorney between now and then, of course, so you're both prepared. Mr. Bratt, I will ask you to submit at least 7 days prior to the trial date your proposed jury instructions and verdict form, and copy that to Mr. Thompson. Mr. Thompson, just file any additional instructions you want to request or any objections you have to the prosecutor's instructions. Mr. Bratt, any other matters we need to address today?
Not at this time, Your Honor. Thank you.
Thompson.
Nothing for the court record.
Ms. Sheldon, do you have any questions about how we're going to proceed? Okay, thank you. That's all. Mr. Vernon, are you here for any matters other than Mr. Eisenhower?
No, I misread the calendar. I thought it was 9:15.
Okay.
So
Are you ready to go on this case?
he's lodged. When they can bring him over, we're ready.
Okay. Got some time, so if you're ready to go, we can try and take that one early.
Thank you.
Okay, so we'll take a short recess. We'll come back on the record. We're on the record in People versus Travis Eisenhower, case number 245362. If I could have counsel with your appearance.
Tara Cook on behalf of the people.
Adam Byrne on behalf of Mr. Eisenhower, who's present, standing to my right.
This is the date and time set for sentencing in this matter. The record should reflect Mr. Eisenhower's present here in the courtroom today. Eisenhower, did you have an opportunity to go through the sentencing report? Vernon, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to this one?
Really not.
Ms. Cook, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this one?
No, Your Honor.
Anything on behalf of the people for now?
Your Honor, I have known Travis for a very long time. Through my job, I've dealt with him on a pretty regular basis. He's only 37 years old, but he already has 3 felonies and 8 misdemeanors. Frankly, I just don't understand why he's not learning his lesson. Either he likes to go to prison or what, but every single time he gets out, he gets off, he's back at it. He can't kick the cat habit and doesn't seem to want to kick the habit. I don't know that there's much we can do. His guidelines are high. He's at 65, and the next time we have him, when he gets out of prison again, he's going to be maxed out and even higher. I just really honestly don't know what to do with him. I hope that he realizes this isn't the life he wants, because at 37, he probably has a chance at something more than this. But if not, we're just going to keep seeing each other. I don't have anything else to add.
Thank you, Mr. Byrne.
And I understand that Mr. Eisenhower's history works against him. I would point out a couple of things. The amount of drugs in his possession was minuscule. The drugs were found in the tip of a needle that was in his possession. That doesn't condemn, I mean, that's still a crime, and he admitted to that. I think it gives some perspective as to, you know, the danger he poses to other people. I think that is minimal. Despite what Ms. Koch has identified, Mr. Eisenhower actually working with me spent a great deal of time trying to get him into or find a treatment program that would accept him. We were unable to do so. His desire to kick the habit, as Ms. Koch identified, is a strong desire to do that. We would ask the court to consider something in the county jail sanction in the 10 to 12 months on the low end of the guidelines. With a focus on that rehabilitation. I think at this point in Mr. Eisenhower's life, he is committed to rehabilitation and getting his life back on track. Again, based on my conversations with him, I think it's clear that he does not desire to continue living a life this way, and he had been working very hard to accomplish that. So we would ask the court to consider something, again, local, so that he could continue to work towards a sober lifestyle going forward.
Thank you, Mr. Eisenhower. Anything you want to say?
Yeah, not just on the rehabilitation thing. I do want to get clean. I was doing great out there. I had a family member pass, which took me a little hard. And now my mom has stage 4 cancer. She was only given 2 months to live. She's been battling it. She's been going for, I think, 7 months now, battling it, beating it, but it's still there. And locally, that's probably I'd be able to see her more. And like he said, I do want to get clean. I don't want this lifestyle anymore.
The report, I'm familiar with. In this case, there's also, of course, a lot of information in that report about you and your circumstances as well. Certainly sorry to hear about your mother, difficulties that you have to deal with for your whole family. I'm sure being locked up doesn't help her, certainly happy to see her. So I certainly have a lot of sympathy for you in that regard. And I hope that she continues to battle well. Looking at the report, you know, I've got to look at the circumstances involving you and where we're at this point in terms of what is an appropriate sanction. I agree that the particular particular crime in this case wasn't particularly serious. You didn't have a large amount of substances. But as the lawyers have said, your past record starts to catch up with you in terms of the scoring, which leads to prison guidelines, which is, the guidelines here call for up to 4 years. I don't think that's warranted because of the nature of the crime here. But the problem with probation or local sanction is if not done well on probation. Prior terms, and every one of them has been unsuccessful. Recently, it's 2023, your last unsuccessful discharge. So, in my view, it doesn't make sense to keep doing that over and over again. It's not something that has worked and hasn't worked up until pretty recently. The recommendation is for 18 months in the Department of Corrections. I think that's a fair recommendation. It's at the low end of the guidelines. Which I think recognizes the lower severity of the crime in this case, but it also involves prison, which I think recognizes your past failures at sanction and your continued reoffending. So it's at the low end of the guidelines. I think it takes into account all the factors here. It's a fair recommendation, and so the court is going to follow that and sends you to the Michigan Department of Corrections for a period of 18 months to 20 years. You have credit for 68 days served, crime victims assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You do have the ability to seek an appeal of this sentence. And Mr. Vernon,
We went over that appeal. He has initialed it in the appropriate place on the receipt. It's been provided to the clerk. He has the 2 remaining, 1 copy to the prosecutor.
thank you. You are remanded to the custody stage, right?
I think it's 14 days. Yeah, that's fine.
Ms. Helva, he asked if she was lodged. She's not lodged here. She's speaking in Sheboygan, but I did not have a writ, nor did I know that she was lodged at all. So I'm not sure.
Let me, let's call that case. Mr. Truce, are you able to hear me okay?
Yes, Your Honor.
Okay. We're calling the matter of People versus Heidi Hellebuck. This is file number 255402. If I could have the lawyers put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Miss Hellebuck. I understand, I think there may have been a mix-up here. Miss Hellebuck is lodged, I think, in Sheboygan's jail. I have been in good communication with her. I've had several meetings with her in the jail. She is set to be released on the 11th, and it was our intentions to proceed forward with the trial. I don't see any reason that we can't proceed forward with it, given, again, the communications I've had with her, and that I'm aware she's set to be released before that date.
Okay. Ms. Cope?
I was not aware that she was in the jail. We're ready to proceed to trial.
Okay. All right. Well, this was the date for the final status conference, and the record should reflect Ms. Hellebuck is not present due to incarceration, as we've discussed. But Mr. Trush, have you discussed with her that the matter of the plea cutoff, and that if she elects to go to trial, that's the way we're going to proceed?
Correct, Your Honor. I would also indicate for the record, there was an offer made that contemplated a misdemeanor, a plea to an attempted R&O. I discussed what the plea cutoff meant. She was not inclined to accept that.
Okay. All right. So we'll proceed to trial as scheduled on August 13th. I'll ask counsel and Mr. Trush if you can communicate with your client, although it is on the notice of hearing, of course, that she needs to be here and ready to go by 8:30 on the morning of the 13th. I believe Ms. Cope's already submitted the proposed jury instructions. And so I think we're ready to go there. Ms. Cook, are there any other matters that we need to address before we go forward with the trial?
No, but I did just confirm that she is in Sheboygan jail.
And Mr. Truce, just for the record, I do have your instructions as well that you submitted. Is there anything else that you need to address for the record here today?
Just two things briefly. One, I would indicate the court made some reference to when Ms. Hellebuck is supposed to be present for the trial. I discussed trial procedure with her as well, when she needs to be there, all of those things. Additionally, I was going to address to the court, I did submit, I think it was 2 instructions that I think weren't tailored by the prosecutor to this case. So I tailored them. Outside of that, we have no objection to the prosecutor's submitted instructions.
Okay. All right, thank you. That's all that we have for that file. Is Ms. Harriman here? Ms. Harriman, if you come up to the podium, please. Go on the record in People versus Angel Harriman. This is file number 255417. The record should reflect Ms. Harriman's present here in the courtroom today. Mr. Truce, how did you want to proceed with this file?
Thank you, Your Honor. I will be asking for one more adjournment on this case. When we were last here, we identified to the court there was a matter in Otsego County. So to kind of give the court the full view of things, there was a matter in Otsego County. Then the matter in Crawford County came up. Then there was a older matter in time in Otsego County that was delayed. We just waived that up to the circuit court. We have a global offer from the prosecutor in Otsego County, and I would say I'm cautiously optimistic that offer may resolve this case as well. So again, I think if the court were to give us just one more adjournment, I think we're pretty close to being there on this one.
So,
I'd have no objection. I agree with that. I've talked to the Otsego County prosecutor about that case there.
okay, Mr. Truce, should we set this for hearing in September then?
If we utilize the mid-month day in September, I think that would be sufficient.
Okay. Ms. Harriman, have you had an opportunity to talk to Mr. Truce about this?
About the adjournment.
Do you have any objection to that? Okay. Okay, so we'll set it for the mid-September date. Ms. Harriman will send you a notice of the date and time of that hearing. Make sure that you stay in touch with Mr. Truce so that we're all ready to proceed at that time, okay?
Okay.
Mr. Truce, is there anything else we need to address for the record on Ms. Harriman's case?
I don't believe so, Your Honor.
Ms. Coe?
Nothing further.
Ms. Harriman, do you have any questions?
No, here.
Okay. Mr. Insler here?
Your Honor,
Yes.
this is the probation violation hearing for him. The court has signed an absconding warrant for him because he failed to report to his probation officer, so it is unlikely that he will appear.
Okay, so this is file number 225113 versus Jonathan Insler. So for the record, I will proceed further on that case once he's arrested and brought before the court.
Your Honor, just for the record, Richard Truce appearing as duty attorney. I did try to make contact with Mr. Kinsler. I was not able to do so.
Okay, thank you. People versus Andrew Mahalik, case number 255432.
Sierra Coke on behalf of the people.
Pronounced it correctly.
I did?
Thank you.
I was just gonna ask you if that was
And
the
it's
correct
perfect here.
pronunciation. Fucked out today.
Thank you, Your Honor. Richard Truce appearing on behalf of Mr. Mahalik. Today's the date and time for a jury status conference. I do believe that we have a resolution for the court here, whereby Mr. Mahalik would tender a plea to count 1 safe breaking under a 1-year delay of sentence. Mr. Mahalik is to pay restitution of $5,000 to the DNR and comply with any other terms the court imposes on the delay. If he is successful in that, it would be reduced to the misdemeanor larceny 200 to 1,000, and that's PAC code 7503563A.
4A.
Okay, and Mr. Trush, is this in the nature of a Killebrew agreement? In other words, would Mr. Mahalik have the right to withdraw his plea if I determined after reading the PSI, I didn't think that was an appropriate resolution?
I do think because the delay is part of the plea that was accurate.
Ms. Koch, is that a correct statement of the plea offer?
I would agree with that. And just so the court understands, this is a DNR case. The allegations are that he stole money out of the tube from the various DNR places. We came up with a restitution amount. I've spoken to our DNR officer about this resolution when we came up with this, because this is kind of a unique, we don't normally do a plea like this. And Mr. Mahalik doesn't have any criminal history. So our goal here is restitution, making the victim whole here. And then hopefully he's successful in all those things and he doesn't lose the benefit of that plea at the end.
All right, Mr. Mahalik, have you had an adequate opportunity to talk to your attorney about this agreement?
Yes, Your Honor.
Is that how you wanted to proceed?
Yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Are you currently on any kind of probation or parole? And you understand that the crime that you're going to be pleading guilty to today has a maximum possible penalty of up to life. With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
It's your own free choice to enter this plea.
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty of this crime? This happened on or about May 23rd of this year, is that correct?
Yes, Your Honor.
And at that time, were you in the Lake Marguerite State Forest Campground area here in Crawford County?
Yes, Your Honor.
And while you were there, did you break into or open up those containers that are meant to hold deposits for people who are camping?
Yeah, in a sense. And
What did you do?
I actually used the grabber tool to go in the slot and grab the envelope out.
Okay. So you gained entry through the opening and removed?
Yes, Your Honor.
Okay. All right. Did you have any legal right or permission to do that at the time?
No, I did not.
Ms. Polk, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Truce, are you satisfied with the factual basis?
I am, Your Honor.
Ms. Polk, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Truce?
I'm aware of none, I'm aware of none, Your Honor.
Ms. Polk, are the people satisfied that the court has complied with statute and the court will undertake this plea?
Yes, Your Honor.
Mr. Truce, are you satisfied? Sorry, I don't know if I got your answer, Mr. Truce.
Yes, I am satisfied.
Okay, Mr. Mahalik, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this crime. The court will accept your plea. You're going to meet with, looks like Mr. Haven here before you meet today, set up a pre-sentence interview. Then we'll set this matter for a sentencing hearing. It's going to be in about 30 days. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then, so that you're prepared for that day, okay?
Okay, I don't know if you notified the court about, wanted to set it maybe in September, because I'm actually, next Tuesday, have an amputation of my foot.
Okay.
Yeah, I
Mr.
was gonna ask, Your Honor, if we could maybe set it 60 days, because again, he's scheduled to have the amputation of his foot, I think, next Tuesday. I just foresee that there's gonna be some rehab, there's gonna be rehab and downtime there. I'd rather be cautious than have to come and ask for an adjournment.
Do you have any objection to that? So,
I don't. I spoke to Mr. Truce, and I know that the defendant is saving up money to work towards his restitution even now, so I think that's fine.
okay, so we'll probably have this set then for October. But again, make sure you stay in touch with Mr. Truce so that you're prepared for the hearing and then also with any developments. Thank you.
And I had to say one more thing. I was, told, Mr. Trush, the DNR guy has, my phones, and I was hoping maybe get my phones back now.
That's something that Mr. Truce can work on for you.
Okay.
Yeah.
All right.
Okay, thank you.
Thank you, Your Honor.
People versus Michael Lovely. Number of files up. File number 225137, 255341, and 25444. Record should reflect Mr. Lovely's present here in the courtroom today. If I could have counsel for your appearances.
Yuriko can be after the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Lovely for all three files.
And Mr. Trush, how did we want to proceed with these cases today?
Your Honor, I'm going to ask for an adjournment of 1 month. I spoke to Mr. Lovely about this. I talked to the prosecutor and the probation department as well. This is a case that was originally signed to Mr. Vernon. I was substituted in on the files probably about 10 days ago. I'm just not up to speed enough for us to be able to resolve it, but I think with a month, we'll be in a position to do that.
Okay, Ms. Coe.
I do not object.
I'm sorry.
I do not object.
Okay. Mr. Lovely, have you had a chance to talk to Mr. Truce about this?
Yep.
Do you have any objection to
No.
that? Okay. All right, so we'll reset this for a plea hearing status conference. As requested by Mr. Truce. Mr. Truce, are there any matters we need other than that to address today?
I don't believe so, Your Honor.
So,
Nothing further.
Mr. Lovely, do you have any questions?
No.
Our next matter is set for 10:15, so we'll finish our recess. We're on the record in People versus Brooks. This is file number 245344. The record should reflect Mr. Brooks is present here in the courtroom today. If I could have counsel put your opinions on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of Your Honor, Jordan Brooks. Your Honor, we're here on a probation violation. Mr. Brooks is contesting those underlying charges in Osceola County. I understand his attorney is going to be doing something about the search as well as possibly going to trial. So at this point, we're asking for an adjournment to allow that case to play out, maybe calendar 60 days out. I don't believe we have a trial date yet, so I don't believe it is. Do you have a trial date?
Yeah.
What's your trial date?
10, 29, 25.
All right, Mr. Brooks advised me it's 10/29/25, so maybe early November.
Okay. It looks like Mr. Brooks has already been arraigned on this. Is that right?
That is correct.
I believe that's correct.
Okay. Mr. Brooks, have you had a chance to talk to Mr. Thompson about this delay in this part of your case?
Yes, Your Honor.
Do you have any objection to that?
Oh, Your Honor.
Okay. Mr. Caven, do you have any objection?
No objection, Your Honor.
Okay. And I was looking at something, Mr. Thompson, can you tell me the time frame?
Yeah, October 29th. It sounds like we have a trial date for that underlying case out of Osceola County.
Okay, so we'll set this for a hearing on the court's November motion day. We'll set it for the mid-month November motion day. So give everybody enough time to get through the trial and decide how they want to proceed with this part of that. Anything else we can address, Mr. Thompson?
I don't have anything else for today's record. Thank you.
Mr. Brooks, did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today. Versus Breaker, case number 255411. But Mr. Brinker's present here in the courtroom today. This was originally set as cause to forfeit bond. Mr. Brinker has appeared before the court today, so the court is going to dismiss that show cause of forfeiture. In terms of how to proceed, Mr. Brinker, I know you're representing yourself, is that correct?
Yeah, correct, Your Honor.
Okay. Did you have an arraignment or a hearing before Judge Burmeister?
I don't think so.
No.
No, I just got found over, sir.
Okay. I just want to make sure, did he ever go through with you the risks and
Yes.
all
Yes,
of that of
Yes, sir.
representing yourself?
Yes, sir.
Okay. In light of the previous hearing that you had with him, where he advised you of those risks of proceeding on your own behalf, did you still wish to proceed?
Yes, sir.
Okay, representing yourself?
Correct.
Okay. You understand that you do have the right to have an attorney,
Yes, sir.
and that Mr. Thompson is here as a standby counsel?
Yes, sir.
If at any point during this or any other hearing in front of me that you want to be able to consult with Mr. Thompson, just let me know. I will take a break and allow you to do that, okay?
Appreciate that. Thank you, Your Honor.
So based on that, the court finds that Mr. Brinker's waiver of counsel is knowing, voluntary, and unequivocal. The court will proceed. Ms. Koch, can you tell me what the prosecution position is at this time?
Yes, Your Honor. We made an offer in February on this case. The case was bound over in April. We've had some adjournments at the beginning of the case in terms of getting it charged and stuff due to Mr. Brinker's health issues. It's about a year old. We'd asked the matter to be set for trial. If Mr. Brinker does not want to avail himself of the plea, which is plea to count 1, operating while intoxicated, third offense, dismiss habitual fourth, and dismiss the DWLS.
Mr. Brinker, have you had a chance to consider that plea offer?
Yes, Your Honor. I wasn't really prepared for this. I thought it was just a hearing for a bond. I apologize.
Okay. Ms. Koch, when was that offer communicated to Mr. Brinker?
It was emailed to him in February. I've talked to him about it several times. We do have a court date. Let me just check. I think it's on the next. No, this is the only court date we have. So I would ask that we set it for trial and we can do a final plea cutoff in 30 days.
So Mr. Brinker, what I'm gonna do is get your case on the calendar for trial.
Your Honor, I was wondering if I could, I didn't know this was gonna be a pretrial conference type thing. I was wondering if I could get a adjournment for, I had a motion for adjournment rather than hospitalized for 4 weeks. And I was wondering if I can get like my ducks in a row and have a new pretrial. This is my first hearing in your court. I wonder if I can get a 6-day adjournment and get my everything in order, because I've been completely hospitalized for the last, and I haven't really thought about this, so to speak, in that context. And I was wondering if I can get 60 days to get my doctor records and all that stuff for this particular case, sir.
On May 27th, he tried to file a motion for a continuance. There was no notice of hearing. I told him he needed to call and get a court date. He said he would do that. That did not happen, and then he failed to show up on the 16th. And then
I was hospitalized.
Yeah, so what I'm gonna do, Mr. Brinker, is get a trial date set. I will build enough time in between now and then to allow you whatever motion you need to file. And then I'll set this prior to that trial date for a plea cutoff. So
Okay.
you'll have some additional time to consider that plea offer.
I appreciate that, Your Honor. Cause I just got, today, I got another micrological report that I have more stuff of wound care. It's positive for more infection in my hand. So I don't know if I'm gonna be back hospitalized here shortly for that. You know, I brought that with me today just to show you. I had 2 surgeries on my hands recently, and now they're saying I have some other bacteria inside of it that will cause it more infection. So I have an appointment to go see a hand specialist and Travers for that. And that's what I'm saying. Like, I don't know exactly what's gonna happen with that if I go back to hospital for another, because I had to be an IV antibiotics in order to get the infection out. And that's what I'm kind of, you know, I don't know. It's whatever the specialists tell me. So I apologize about that. And it was something that I had no idea that even happened. And it was all, I don't know how it happened or whatever, but I had a lot of viruses and stuff in my hands that caused it to swell and have surgeries and stuff. So I apologize.
Okay. All right. So I'm gonna set this for trial about 4 months out. Ms. Coke, how many days of trial do you think we need for this?
We can do it in one day.
So I'm gonna set it for a 1-day jury trial at 4 months out. Our next hearing will be in about 60 days for a status conference. Okay.
Thank you.
And if you have any motions to file, Mr. Brinker, they would need to be set for hearing. And Ms. Spendler's right about the process. If you have a motion.
I gave him notice of hearing that somebody wasn't here, and I gave it to the person across the hall to give to the court, because I did submit some motions, and they did notify me that I needed a notice of hearing, and I went and got it and got it signed and submitted it for the day I was supposed to be here, but I was in Traverse City Hospital, so. Because I had every intention of being here, I was filing motions and everything, so it just, you know, like I said, it wasn't something I had planned.
Yeah, so there's 2 steps to the process. You have to call my office, talk to Jennifer.
I did, yeah, I did that.
So you need to get a date and time from her. And then once you have that, then you need to file that notice.
Yes, sir.
With the clerk.
Yes, sir.
So you'll have 60 days to handle those.
Yes, sir. Okay, thank you.
And you're will the 60 days, the status conference, that'll be the final plea cutoff and date.
Right, so then at that time, Mr. Brinker, you also have a decision whether you want to enter.
Yes, sir.
Okay.
Thank you, sir.
Your Honor, I think today was set up as a motion to potentially revoke the bond. I assume that's not gonna occur.
Right, yeah, that since Mr. Brinker submitted himself to the jurisdiction of the court. Under the court further against forfeiting the bond, either with regard to Mr. Brinker.
Thank you, sir.
Okay,
Thank you.
that's all for today.
Thank you, sir.
Insurance here was set for 45, so that's Go on the record in People versus Daniel Knight, file number 255433. Effective counsel, put your appearances on.
Sierra Cook on behalf of the people.
Jim on behalf of Mr. Knight.
Thank you. The record should reflect Mr. Knight's presence here in the courtroom today. Mr. Hunt, can you tell me the status of this matter?
Your Honor, I've been talking to my client. I'm not sure if this matter is going to proceed to trial or not. Apparently, there's some additional information that I need to review. I would ask that that before we schedule it for trial, if we could adjourn this for 30 days so I could speak with my client to figure out exactly where we're going with this issue. And I could potentially have some more conversations with the prosecutor as well.
Okay, Ms. Coe.
I would be okay with that, Your Honor.
All right, looking at the nature of the charge, this is operating while intoxicated by involving controlled substance, alcohol. I can see there's room for some maybe additional discovery that might be done. So, Mr. Knight, have you talked to your attorney about this?
Yes,
Do you have any objection to this delay?
I do not, Your Honor. Thank you.
Mr. Hunt, do you think 30 days is that going to be enough time to?
I think it should be, Your Honor. If for some reason I need more time, I'll speak with the prosecutor about it and maybe we can put together some agreement about the time frame. But I think 30 days would be adequate.
Okay. So we'll set this for another status conference / plea hearing in 30 days. Anything else I can address for your side today?
No, Your Honor.
Ms. Koch,
No, Your Honor.
Mr. Knight, do you have any questions about how we're going to proceed?
Not currently. Thank you, Your Honor.
Okay, all right, thank you.
Thank you, Your Honor.
Court will call People versus Richard Adams, file number 255414. I can have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson, I'm the attorney for defendant Richard Adams.
Okay, this is the date and time for a show cause regarding Mr. Adams' failure to appear show cause hearing to forfeit bond. Mr. Thompson, have you had any contacts with Mr. Adams?
I have nothing to report, no developments since he failed to appear for that earlier hearing, Your Honor.
Ms. Koch, can you take any position on how the court should proceed today?
No, we have no additional information either. It's been a couple of months and he's still not appearing.
Okay, the record should reflect that the show cause order in this case was signed on June 25th. That both Mr. Adams at his last known address and his bondsman, Craig's bail bonds, were notified of the date and time of today's hearing. Mr. Adams had failed to appear on June 16th of 2025. Court issued bench warrant for his arrest on that date. Notice of his failure to appear was provided to Craig's bail bonds on June 24th, so the court finds that was timely within 7 days after his failure to appear. This hearing today was set for 10:45. It's now 10:52. Neither Mr. Adams nor Craig's bail bonds has appeared. Show cause why the court should not sign that judgment following the hearing here. Mr. Thompson, anything else we can address for yourself?
I don't have anything further for today's court record.
Nothing, Your Honor. Thank you.
All right, the court will then continue this case until Mr. Adams is arrested and brought before the court. Our next hearing set for 11:15, be in recess until that time.
Offer.
What's that?
I said I should have given him the offer. I screwed up.
All right, we're on the record in People versus Derek Bancroft. This is file number 25554.
Joseph Derek Bancroft, Sierra Coke on behalf of the people.
James Dick on behalf of Mr. Joseph Bancroft, who's standing to my right, Your Honor.
Thank you. This is the date and time set for sentencing in this matter. Mr. Bancroft, have you had an adequate opportunity to go through the recent report and talk to Mr. Dick about that? Yes, sir. Counsel, is there any deletions or corrections to that report?
No, Your Honor.
And Mr. Dick, are there any challenges to the scoring of the guidelines?
No, Your Honor, there's no.
Ms. Coke, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything that you would like to say on behalf of the people for the allocation?
There's been multiple impact statements provided. I'm not going to read them again. I've been dealing with Mr. Bancroft pretty much since the beginning of my tenure here. He seems to have a tumultuous relationship with the people he's in a relationship, and now that is moved over to his child. When he is sober and on track, he is doing well. When he is not, this is what happens. I have given him lots of breaks. This is, I think, his first felony. It is. This is the third RNO situation I've had with him. I think it was the last one or the one before. I watched one of the sergeants carry him out of a coat closet like a suitcase because he refused to come out when the police ordered him to. I don't know what Mr. Bancroft, when I hear it's sort of a funny joke, but it's not really funny as it applies to Mr. Bancroft. You have you have all these rights and he just can't stop himself from the things he says, especially when he's drinking. I really hope that this is a wake-up call. He's 37 years old. He's got kids. He's got family that care about him. He's got a great support system. But at some point, you have to learn that, you need to stop drinking. That's what has to happen. You need to stop drinking, do what the police tell you. And if we would be dealing with another misdemeanor with him. But again, this is the third time around with this RNO situation where he's just not learning his lesson. And I hope this is the end for him. I hope we don't see him again. I'd ask the court to follow the recommendation. Thank you.
Thank you. Mr. Dick, anything on behalf of your client today?
Yes, Your Honor, we'd like to start at the recommendation itself. That is, the PSI does recommend 60 days in jail. In addition to the probation, we are arguing that the court should consider just a straight probationary period or a reduced time in jail. So, of course, it is a intermediate sentencing cell, which recommends that it be something other than jail or prison. The guidelines are 0 to 17 months. And of course, as the courts are well aware, the intermediate sanctions are generally intended for offenders that do not require a prison sentence. So the court has the flexibility to choose not to do so. But they also have the ability to do so. The PSI provides several supporting factors for non-custodial alternative. The rehabilitation goals here, the report outlines it like a clear path for rehabilitation, including completing substance abuse counseling, maintaining sobriety, employment. Mr. Bancroft has already started outpatient substance abuse treatment through the Grace Center and domestic violence counseling with the Grace Center in coordination with the Department of Health and Human Services for a CPS case that is running alongside of this matter. The other portion of it is his employment. He has been employed since March with the same company as a chipper operator with a tree service. And he is a high school graduate, so that the report notes that those are strengths for the consideration here. His continued employment is a special condition of his recommended probation. And specifically, if he goes to jail for 60 days, he loses his employment. So it also says that he would have to make diligent efforts to seek employment I'm guessing that was in the instance that he lost it for some reason, but it says that he cannot quit or voluntarily quit or essentially sabotage his employment. Mr. Bancroft also has the motivation for this change. One, he's never been in a circumstance where his children have been taken away from him. Yes, alcohol has been a problem for him for roughly 20 years of his life. He has a rather short criminal record comparatively to many of the people that stand before you, Your Honor. However, the only reason he has any criminal record is because of the alcohol and the choices that are made to drink and then the effects of it. Here, he is motivated to complete all of the programs that he is required to through probation, as well as through the Department of Health and Human Services. They already have a plan laid out, a treatment plan laid out for him, and provided some reports as well as letters of support for today. So his family getting back together serves as a strong incentive for complying with his probationary terms, if the court would choose to just assess him a probationary period. And again, the probation with emphasis on treatment as opposed to putting him in jail would align with the purpose of the intermediate sanction cell and be more effective in promoting his rehabilitation, ensuring public safety, and perhaps helping to ensure that that he doesn't drink anymore. All of the agencies have reported that he is doing very well. And if the court would permit, I do have a letter initially that I'd like to read to the court from the foster care case manager in his CPS case. Ms. Coe, do you have any objection to that?
No.
Okay. All right. It's from Brooke Portman with Child and Family Services, Northeast Michigan Family Resource Center, signed 8/7, so she actually wrote it today. She mislabeled the introduction. She wrote to Judge Burmeister. But this letter is to detail the services and progress Joseph Bancroft has shown. On his own, Joseph has set up his own counseling through Grace Center, which is substance abuse counseling. Joseph has never missed any parenting time, and when given the opportunity to see his children more, he never turns it down. Joseph arrives at parenting time, on time, and sober. This is shown in the 2 drug tests that are attached to this letter. And just coming off the letter for a moment, there are 2 drug tests that show he tested negative for everything both times that he did test. And returning to the letter, Joseph and his daughter Jocelyn have just completed a therapy session with Pam Fisher. I spoke to Pam after this session. Pam stated that it's important for Joseph and Jocelyn to have parenting time and to continue to talk in a therapeutic setting. Joseph is willing to complete these services and has even started the services without being asked. While service will continue if Joseph is incarcerated, his incarceration will delay some services. I would ask that you take into account that Jocelyn and Joseph have just begun repairing their relationship and the impact this would have on all 3 children. Thank you. Brooke Portman, Foster Care Case Manager, Child and Family Service, Northeast Michigan Family Resource Center, dated today's date. Your Honor, then there's also a letter from the Grace Center dated today's date, signed by a Jody L. Robson. And they have the professional accreditations beside their name, MA, LPC, CAADC. If I may continue to read this one. Says it's dated August 7th, 2025. Client Joseph Bancroft, sent to Mike McFalda, MDOC Probation Officer, Brooke Portman, caseworker, Northeast Michigan Family Resource Center. This report indicates the progress of the above individual currently enrolled in outpatient treatment. Attended appointments, 2. Client cancellations, rescheduling, 0. Failure to show for appointments, 0. Attendance is labeled as good. Attitude is labeled as good. Motivation is labeled as good. Participation is labeled as good. Progress is labeled as fair. There are 4 cells in the attendance, attitude, motivation, participation, and progress. Excellent, good, fair, and then poor. The comments read, Joseph presented to outpatient counseling following a domestic violence assault offense against his teen daughter. He reports a history of domestic violence charges and also reports that he was under the influence of alcohol when the recent event occurred. He reports that he has not consumed alcohol since the incident and that he takes the situation seriously. Joseph displayed a positive attitude and engaged in both the intake and follow-up session. He indicates efforts to utilize positive coping strategies and supports. Signed, Jody L. Robson, MA, LPC, CAADC. Your Honor, there are additional items that were included here, one of them being a Michigan Department of Health and Human Services Parent Agency Treatment Plan. This is the latest treatment plan, and it was completed by Brooke A. Portman of the Child and Family Services for Northeast Michigan. Here, the gist of it is that Mr. Bancroft, he is employed, he is meeting his needs and the needs of his children. He doesn't have any health issues. He is taking responsibility for the issues that have happened here. And he is taking steps to correct them. This treatment plan lays out specific outcome goals. The desired outcome here says it's to live a life of sobriety. The expected achievement date is presently set as October 16th of 2025, and the progress evaluation is a partial one. However, the action steps here provided by the Child and Family Services of Northeast Michigan state that the agency will provide Joseph with random drug screens through forensic fluids, and the agency will assist Joseph in setting up counseling and substance abuse classes. He has agreed to participate in random drug testing, counseling, and agrees to discuss his substance abuse issues. He has agreed to participate and show benefit from substance abuse counseling and any other recommended substance abuse class or programs that the agency may require. Another needs and outcome here is emotional stability behavior. The description of this was Joseph was arrested for child abuse and assaulting a police officer. The goal here will be able to regulate his emotions. Desired outcome, to utilize skills learned to effectively balance stressors. The expected outcome or achievement date is October 16th of 25. And again, this is another action step. The agency will ensure that Joseph is set up with counseling and psychological evaluation. The agency will request progress notes and then submit them to the court. Of course, they're speaking of the probate court. However, if this court also required that to be submitted, that will also be submitted. Joseph will participate in counseling through the Grace Center. He will sign a release of information for the case manager to request progress notes from the Grace Center, and he will benefit from the counseling and will use the skills learned to effectively parent his children. Joseph will participate in a psychological evaluation, follow any recommendations from the evaluations. Your Honor, so this is That's only the second of four action steps. But what I'm trying to explain here is that there is a plan, there is action that has been taken. And I do want to say that Mr. Bancroft has already served rather harsh punishment since April, where he did not see his children at all for a period of time, for the first time in his life or theirs. His daughter is 14 years old. His youngest, I believe, is 5. Thank you. My apologies. 4. My apologies. He has 3 children. He has done everything in compliance with the court. He has abided by the terms of his bond in this matter. Everything here suggests that he is on the right track to do the right thing and to continue to do the right thing. As mentioned in the beginning, the alcohol being the issue. Mr. Bancroft, again, has never had his children removed from his care or custody until this particular incident. And this is a 37-year-old father's wake-up call that alcohol can never be consumed by him because it does not make proper choices in doing so. He is aware of that, and he wants to be there for his children. His children need him at this time as they are all coping with this separation as well. Excuse me. Did the court receive a copy of the victim impact statement?
Yes.
Yes. Okay. I won't read that then, Your Honor, but with all of that being taken into consideration, we do ask the court to consider the straight probationary period or a reduced jail term. If the court would not forego any jail term, perhaps there would be some sort of work release or something otherwise to allow him to maintain his employment and support his family. Thank you.
All right, thank you. Sir, anything you wanted to say to that?
No, sir.
Okay. I did read through the report, so I'm familiar with the circumstances that bring you before the court in this case. And there's also a lot of information in that report about you personally and your circumstances and history. I take all of that into account along with what your attorneys had to say and the efforts that you've made since this incident to, number one, address your issue with alcohol, number two, forward with your family life, and then, of course, I take into account what prosecutors had to say as well. I do think this is a case based on the efforts that you've made since this happened, a case where there's a strong possibility of rehabilitation. I think that's a good thing. I think that gives the court, number one, reason to order probation in this case. Number one, to supervise you to make sure that you remain on the right track once this case is over. But also to recognize the efforts that you've made since this incident occurred. There are some, and I think those are all things, again, which I think gives the court an expectation that you would successfully complete probation, and so that it would be in the community's best interest to do that as part of your sentence. I also think there's some factors here that work against you. You do have one prior conviction for domestic violence. That was back in 2014. Since then, 2017, 2018, 2021, and 2023, you were charged with domestic violence. So 4 additional times, none of those resulted in convictions. But you've had at least 4 incidents since your conviction and prior to this one, where you've been charged with domestic violence. In that time, also 2 convictions for resisting or obstructing, which tells me that at least until this point, there hasn't been a change in your behavior. I'm certain based on what I read in the report and what everybody said here today, that alcohol is a major contributing factor to that. Some people can use alcohol and it's not a problem. Some people just can't. And I think you're one of those people that just can't in any amount at any time for any reason, because you get yourself into trouble, as the lawyers have indicated and as the report reflects. Given the circumstances here, given your past history, I do think it's appropriate to impose a penalty here. I think all the things that you've been doing convinces the court that that penalty should be limited. I could sentence you up to 12 months in jail on this. I don't think that's appropriate, again, given your efforts at rehabilitation and the expectation that you can move forward from this and not repeat the same behavior. But I do think that a penalty is appropriate for what you did in this case and your failure to correct your behavior up till now. So all of that being said, the court is going to adopt the recommendation. I think it's a good recommendation. I think it recognizes the mitigating factors, but also the need for punishment and deterrence. So the court is going to sentence you to probation for a period of 2 years. If you do well on probation and you comply with all the conditions, then you may be able to be discharged earlier, up to 1 year earlier. So I hope that that's a motivating factor. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. I think one of the most important of which is that you not use or possess any alcoholic beverages or other intoxicants, or be in bars or other places where the primary purpose is to serve alcohol or drinking. But the court is also adopting all the other conditions, including that you attend and complete any mental health, domestic violence intervention, or other recommended treatment that's recommended to you, and that you not engage in any assaultive, abusive, threatening, or intimidating behavior. The court is going to order that you serve 60 days in the Crawford County Jail. You do have credit for 2 days served. The court is going to order that you pay a crime victims assessment, the amount of $130, court costs of $325, attorney fees of $350, the state cost of $118, and a supervision fee while you're on probation of $30 per month. That all applies to the resisting or obstructing charge as the domestic violence count. 60 days in the Crawford County Jail with credit for 2 days served. Those sentences to be served concurrent to each other. Court is going to order that you serve that sentence up front all at once. So we'll be required to report to the jail immediately. You do have the ability to seek an appeal of the sentence, and Mr. Dick, have you provided your client with his appellate rights?
Not at this time, Your Honor.
It should be on the table if you can have Mr. Vancraftoft acknowledge receipt of his appellate rights. Ms. Vancraft, you're in.
For me, Sue?
Yep. One Sarah, one minute. Thank you. Most people forget me. I get the signed one. So hers has to be signed. Sarah's. Yep, perfect.
All right, People versus Jane Bardo, case number 255424.
Sierra Coca, behalf of the people.
James Dick on behalf of Mr. Bartow.
Thank you. The record should reflect Mr. Bardo is present here in the courtroom today. This is the date and time set for sentencing in this matter. Mr. Bardo, did you have a chance to review the pre-sentence report and go through that with me? I did. Mr. Dick, are there any additions, deletions, or corrections to that report?
I'm gonna say there or not, but I just realized you said Jane. His name is Jamie.
Jamie.
It appears to be correct on the report. On the PSI.
Yeah. Okay.
So there are no additions, deletions, or corrections, Your Honor.
Okay, Ms. Coke, do you have any corrections to the report?
No, Your Honor.
Anything on behalf of the people for delegation today?
Your Honor, I think the recommendation is appropriate. I hope that he takes advantage of the 7411. We know as a court that people get offered this a lot and a lot of them are not successful in it and it can change their life pretty dramatically. Mr. Bartow has never been on my radar and has popped up a couple of times now. He only has one prior misdemeanor and it's, it looks like it's a traffic offense. And then he had a couple of things that were dismissed. I would ask the court to follow the recommendation. Thank you.
Thank you. Mr. Dick, anything on behalf of your client today?
Likewise, we would ask that the court adopts the recommendation. Mr. Bartow, he has been essentially a stay-at-home, soon to be step-parent to his fiance's child while she's able to work. Saves them somewhere between $400 and $500 a week in childcare. He was a tradesman, generally worked on bridges and highways. However, the circumstances that he's currently in suggested that, or made him believe, and his fiance believe that it would be best for him to tend to the child rather than go out and seek additional employment, try to make up the difference in the money. So with that, Your Honor, yeah, Mr. Bardo, he doesn't have a significant criminal history. And it's my belief that he will, in fact, adhere to the terms of probation and he will successfully the 7411. We just ask that the court takes into consideration the familial employment status as fines and costs are assessed in this matter.
Thank you. Mr. Bardo, anything that you wanted to say today?
No, just that I made a terrible mistake and I'm going to do everything I can to make it right again.
All right, I did read through the report, so I'm familiar with the circumstances here. There's a lot of information in that report about yourself and your background as well. Take all of that into consideration, including what the lawyers had to say here and yourself as well. I think probation under 7411 is an appropriate resolution of this matter. I think it's going to give you an opportunity to have this come off of your record if you successfully complete the probation. There's really no downside to the community. If you're able to complete your probation successfully, it's good for everybody. And if you're not, then we'll be back here and figure out where we go from there. Your lack of any serious prior history, again, I think also direct support towards the probationary period. Again, pursuant to 7411. The circumstances of the crime itself, where you had a small amount, looks to me from what I read like a personal use amount. It doesn't look like we're distributing or selling, dealing with large amounts. That's not to say that this is a good thing or it's healthy for you, particularly if you're going to be caring for a child. You need to be in your right mind, so you need to not expose that child to those kinds of substances, which are very dangerous. So personal use amounts or not, that's something that around you at all, and of course, the court is going to follow the recommendation and sentence you to probation for a period of 1 year pursuant to 7411. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. I think under the circumstances, an initial term of jail is necessary, but you need to understand that you violate your probation. It's something that will be on the table. Your family's financial situation or your need to care for that child will not be a consideration. Because at that point, if you violate your probation, it'll be apparent to me that that was less important than doing other things to you. And so then there's no reason for me to put more importance on it than you have yourself. So I just want to caution you, and I hope that that's an added motivation to you to comply. The court is going to impose the crime victim's assessment of $130, court costs of $325, attorney fees of $350, $50 state cost, and a supervision fee of $30 per month while you're on probation. Some of those fines and costs I can't do anything about. I'm required to impose by statute. Some things like court costs or attorney fees, you can do community service, things like that, rather than paying those. So that's something you can talk to the probation agent about in terms of how to avoid the financial hardship of those by doing other things when it comes to that. Because this is pursuant to 7411, there is no appellate rights. Mr. McDowell, are you going to meet with Mr. Bardo here?
Yes, I am.
So just touch base with Mr. McDowell before you leave, and you'll let me go.
Thank you, Your Honor. Thank you, Your Honor.
Stop. Mr. Vernon, were you ready with Mr. Law's case?
Yeah, yeah.
People versus David Law, file number 255382. The record should reflect Mr. Law is present here in the courtroom today. If I can have
Sarah Coke on behalf of the people.
And Vern, on behalf of Mr. David Loud, who's present, standing to my right.
This is the date and time set for sentencing in this matter. Mr. Law, have you had a chance to go through?
Yes, Your Honor.
Mr. Vernon, are there any additions, deletions, or corrections?
The only addition I would say is that I was made aware of a letter from the victim, Amanda Hall, this morning. I don't know if that has been added to the report or not.
As not, and I should read that. And then fix that. Oh, wait. Get that. I didn't have a chance to read it, so let me go with that. Okay, I did have a chance to read that letter. Did you want that attached to the PSI?
Yes.
Any other additions, deletions, or corrections?
No.
Any challenges to the scoring?
No.
Ms. Coke, do the people have any additions, deletions, or corrections?
No, Your Honor.
Does Ms. Hall wish to address the court today to your knowledge, other than the letter?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, when I looked at my notes in my last domestic violence case with Mr. Law, I read almost exactly the same thing from Ms. Hall a year ago. She didn't want any of this to happen. She didn't want him violated. He was hurt by her actions. Frankly, Mr. Law had almost no criminal history. I think he had an impaired driving in 2015, and then the domestic violence in 2024. With a couple other misdemeanors. Somebody that goes from that type of criminal history to what we had in this circumstance, I mean, usually we see somebody who has a much longer history. You know, he's only 34 years old. We gave him what I thought was a very fair plea offer. I think the recommendation is appropriate. I hope that Mr. Law learns from his actions and that we don't see him again. Thank you.
Thank you, Mr. Byrne.
Your Honor, the guidelines here are 7 to 23, the recommendations for 11 months. We're asking the court to consider something at the low end of the guidelines. We're asking the court specifically to impose the 7 months. Mr. Law has acknowledged that his actions here were a series of poor choices. I think the underlying or overriding focus for Mr. Law has been trying to maintain a relationship with his children. He's made poor choices in an attempt to do that, violating the court's order and engaging in this behavior clearly as part of that. Consistent with the letter that we have from Ms. Hall, she is a strong support system for him so that when he gets into a situation where he's confused and he wants some input and some advice, he often goes to her, leading to this causing even more stress and problems and concerns and anger on his part because he's not sure who he's supposed to go to talk to assist him with making decisions. So I acknowledge, and I think he acknowledges that the focus here has to be on co-parenting and whether any further relationship develops with Ms. Hall, is not the focus. The focus is on managing the children in an appropriate way, having a good relationship with Amanda as a co-parent, not necessarily as a significant other. I think he understands that based on my conversations with him. His goal here is just that, to address these, to come up with sufficient tools and other community resources, personal resources, support system, so that when he has concerns and questions and he's not sure what to do, that he has the appropriate people to talk to and address those issues. So he doesn't end up doing things that are in violation of court orders or that are scaring people. And I think he understands that. I think that there are some services in place here under the terms of probation that will assist him with that. So we would ask the court to consider the low end of the guidelines, where the focus here has to be on providing him with additional tools and not necessarily on punishment.
Thank you, Mr. Law.
Yes, Your Honor. I just want to make this perfectly clear that you'll never see me again. I just want to focus on my children and not necessarily Amanda. Just developing a good co-parenting and just making better choices for her and I, for our children. Because they are going to be impacted, not seeing the father, and they have been impacted this whole year, not seeing as much as I was before I lived with them. No father should have to go a day without seeing their children. And I've gone many days, and it's hard. So that's it.
I did read through the report. I'm familiar with what happened in this case. I presided over a number of different hearings with you, so I'm familiar kind of with the circumstances generally and how things have gone for the past year or so. So I'm really familiar with the facts here. I take all of that into consideration. I've heard what the attorneys had to say. I've read the background information in the report about you and your circumstances generally. I read Ms. Hall's letter, your reports just now. And it does seem like things have really gone awry for you recently, and that generally there hasn't been issues. You don't have any kind of serious prior history. So what that tells me is, you know, there was a problem here between you and Ms. Hall that escalated, and at least from your ability to control your actions got out of hand. And those things happen in relationships, but you know, people have all kinds of things that go wrong in relationships, affairs. That happens every day. That is not a unique or a new story. Not everybody does the kind of things that you've done. And so that tells me that there's some additional underlying issues there with you that need to be addressed. And I think you are addressing them, and I hope that you continue to do that. I think what Mr. Vernon and yourself have said, focusing on co-parenting and focusing on what's good for the children, not what's going on between Ms. Hall, is absolutely correct. I think that's the kind of point of view that's going to help you move past that, not have a repeat of these kind of incidents. I think a probation is appropriate here. I think some supervision to make sure that you stay on the right track, particularly given the issues that we've had during the pendency of this and other cases, will help you stay on track. It gives me and the court and the community, and probably Ms. Hall as well, some assurances that there aren't going to be more repeats of this kind of behavior. I do think that a period of jail is appropriate to address your wrongful conduct, punish you, so that you understand that this isn't going to be tolerated, that it's behavior that has consequences to you directly. It's unfortunate that it affects your children as well, but those are their choices that you've made and actions that you've taken that having that effect. I think it's also important for the deterrent effect. These kind of situations can go from bad to worse really quickly. It result in serious injury or death to spouses when people don't follow court orders. When a court order isn't enough to control a person, it gives law enforcement, the victim, everyone involved in the case, concerns that that person isn't going to stop at all when they know there's a court order in place, and that doesn't prevent the conduct. So I think the community as a whole needs to see that when there's an order in place, when there's not supposed to be contact, there's a situation like this, if the person has to obey those orders or again, face some consequences. And that's again for the safety of the people involved. So for all of those reasons, I think a jail sentence is appropriate. The court could sentence you to almost 2 years in prison for this. I don't think that that's warranted under all the circumstances here. I think a sentence at the low end of the guidelines will address the issues of punishment for you and deterrence. And I think the recommendation is appropriate. It's at the low end. I think it adequately addresses those concerns of the court along with the probation. The probation is going to start out as a lengthy term, but you do have the ability to cut that term in half. If you're in compliance, things are going well, there's no reason why you can't be released from probation significantly sooner than what the court has ordered.
Judge, there are restrictions on some offenses and aggravated stalking as well. It's unfortunate.
Okay, so there isn't any.
There would not be.
Okay. All right. So I was wrong about that. I forgot about the charge in this case. So the probation isn't going to be something that can be shortened. Yeah, so making sure that people have any sense of security for Ms. Hall, even though she expressed that she's not worried about that. As Ms. Polk indicated, that's something that's got to be worked. So the court is going to follow the recommendation. I find that it's well tailored to the situation here and sentence you to probation for a period of 5 years. The court is going to adopt as the conditions of the probation all the terms and conditions listed in this report. Where it's going to order to serve 11 months in the Crawford County Jail. You do have credit for 40 days served. Practice assessment $130. Court costs of $325. Attorney fees of $350. $68 state costs. $30 per month supervision fee while you're on probation. Those all apply to the aggravated stalking charge. As to the domestic violence second, the court is going to order 6 months in county jail with credit for 40 days served. That time to be served concurrent with other sentence and a $50 state cost. You have the ability to seek an appeal of the sentence, and Mr. Vernon, have you been able to go through color rights with Mr. Law?
I did. I went through that and he signed the receipt. The court has the signed copy. He has two, prosecutor has one.
Thank you. Mr. Law, you are handed to the custody of the county.
I have one question with regard to the sentence before he left.
Yes.
Based on the statement that Mr. McFarland just made, the first paragraph of the recommendation appears to be inconsistent. It identifies with the second sentence that the defendant would be eligible for early discharge provided they have completed at least 50% of the community supervision and met rehabilitation goals. Would it be appropriate to either strike that, or one of those things ought to happen? It either be allowed or struck.
Right. So, Mr. McFarland, you're indicating the statute does not.
That's mandatory 5 years probation, aggravated stuff.
Okay. So we'll strike that portion of the PSI then.
That's the only question I had thinking on.
It's 11 months, not 6 months.
It's 11 months jail and you get credit for 40 days. Okay.
Thank you, Mr. Chairman.
Take those with you.
So that's Mr. Carey, I've just got some individuals here that I'm not sure if they're connected to your case or not, so it's going to be just a second. Mr. Opaleski, can you tell me what case you're signing in on?
Yes, Your Honor. I am here on Schroeder Family Trust versus Grayling Charter Township.
Okay. Is there anybody else here in the courtroom that's here on the Schroeder Family Trust versus Grayling case? Okay. All right. I think that I've got everybody connected who should be connected on that. So we're on the record in Schroeder Family Trust versus Cox Trust. This is case number 2411683. And if I could just have all counsel put your appearances on.
William Carey appearing on behalf of the plaintiffs.
Good afternoon, Your Honor. Larry Opaleski appearing on defendants Frank M. and Lisa M. Ingalls Trust, Leonard Buck, Shirley Buck, Timothy J. Mauk Trust, Christopher Erickson, Natasha Erickson, Brandon Q. Martin, Jeffrey S. Smith, and Luann M. Smith Trust Number 1, Cheryl D. Zadunik Trust, Sheila K. Fortino, and Charles Fortino, and the Howard A. Becker Irrevocable Trust.
Okay, thank you. This is set for a status conference in this file today. Mr. Carey, can you tell me where things are at from your standpoint, please?
Yes. 2 months, approximately 2 months ago, we facilitated this matter. Facilitation resulted in a memorandum of understanding as to a settlement. And because it's a complicated real estate matter, we wanted to reduce our memorandum to a more specific writing. Since the conclusion of facilitation, Mr. Opaleski has prepared a proposed judgment intended to capture the agreement reached at facilitation. I have received it. I've reviewed it personally. I'm meeting with my clients next week to review it. And that's where it stands. If there are issues with any of the language in the consent judgment, it appears to me that there are issues that can be resolved. So we're likely headed toward a consent judgment in this matter within the next 90 days, certainly. That's my take on all of this, and I'm sure counsel will correct me if he sees it differently.
Okay, thank you. Mr. Opaleski?
That's my understanding as well, Your Honor.
All right. What I'm going to do, I mean, normally I would want to have it done sooner, but I get may take some time given the number of parties and the nature of the issues here. I'm going to set this for a kind of a control date, status conference 90 days out, with the idea that the parties will be able to finalize language and have the consent judgment or whatever closing documents submitted to the court so that we can close the file within that time. But if not, then that gives us another opportunity to check in to see what the holdup is and whether the court can do anything to help get the matter finished out. Mr. Carey, do you have any objection to that?
Not at all.
Mr. Opaleski?
No, Your Honor.
Okay, Mr. Carey, anything else I can address for your side today?
No, sir. Thank you.
Mr. Opaleski?
Thank you. No, Your Honor.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you, Judge. Thanks, Larry.
Thank you.
Ms. Thompson, what case are you signing in on?
On the Hollister matter, Your Honor.
Okay, we'll go on the record in Hollister versus Hollister. This is file number 2411759. If I could have both counsel put your appearances on.
Your Honor, Attorney Kelly Thompson on behalf of Leslie Hollister, who's present with us on Zoom. Looks like she's muted.
Good afternoon, Juanita Massey, appearing on behalf of Brent Hollister, who's seated to my right.
Okay, this is set for a status conference today. I see that parties did participate in mediation in June, that the case was not settled. Ms. Massey, on behalf of plaintiff, how did you want to proceed? Do we want to attempt any further mediations or negotiation? Do you want the court to set this for a bench trial? On behalf of plaintiff, how did you want to proceed?
I believe just set for a bench trial. I don't think mediation's gonna get the parties any closer to where they were.
Okay, from plaintiff's side, what are the issues that the court's gonna need to decide?
There's some outstanding debts, marital debt. And I know the other side is arguing for spousal support.
Okay. All right, Ms. Thompson, do you agree that's how we need to proceed?
I agree, a trial is appropriate at this point, Judge.
Okay. Ms. Massey, how much time do you think the court needs to set aside for the hearing?
Probably a half a day.
Okay, Ms. Thompson?
I would agree with that.
Okay. And Ms. Massey, how much time do you need to be ready, or when do you want the court to get this set?
I think anywhere from 30 to 60 days out is appropriate.
Ms. Thompson?
I would agree with that as well, Your Honor.
Okay. All right, so I'm going to put this down for a half a day bench trial at about 60 days. I will not schedule any additional hearings between now and then. I will ask both counsel to exchange witness and exhibit lists 7 days prior to the hearing. And I will ask each of you to provide the court with a trial brief that sets forth your proposed division of property, or proposed for spousal support, the division of assets and debts, and then exchange that with each other too. That way, prior to the bench trial, I'll have an idea of exactly what the issues are and what each side is asking for. That'll help me be more prepared to be able to rule on the day of trial. Ms. Massey, any other scheduling matters or things you think we need to address prior to the trial?
No, Your Honor, thank you.
Okay, Ms. Thompson?
Just a clarification, Judge, when did you want those trial briefs? Was that 7 days before trial as well?
Yes. Yep.
Nothing further, thank you.
Okay. I'll put what we discussed today into a status conference order and send that out to the parties, and then you'll all receive notice of the date and time of that bench trial. Because it's an evidentiary hearing, it will be in person here in the courtroom in Grayling, and the notice will specify that as well. And that's all I have for today. Thank you. You're all free to disconnect at this time.
Thank you, Your Honor.
Okay, we're on the record now for some juror show causes. And I'm sorry, I thought I had on my docket that's set for 2 o'clock. So,
Gave us time to get the questionnaires completed.
and I guess any stragglers would have had plenty of time. So we're on the record now. So I guess I would just ask you guys who we have left here, and is it based on?
Okay, so for the big packet, Mr. Burns and Ms. Field are absent.
Okay.
Ms. Williams is absent, but she sent that email in. She was diagnosed with strep throat. I told her as soon as she was able, she needed to come in and see me ASAP, complete that questionnaire.
Okay.
And then we have Mr. Vessel Miller, who refuses to complete the questionnaire, and wanted to take that up with you.
Okay.
That's number 7.
Oh, I see. Okay. And everybody else that is here, it was for failure.
It's for the failure to appear, correct?
Okay. And not for the questionnaire part.
Correct.
Okay. And of the folks that are here, how many of them responded based on personal?
4 of the, for the appearance.
Yeah, who had to be, of the people that are
Personal
here, who had to be
service
served
was,
personally?
personal service was the Stephanie Miller, and then all your questionnaires. So the ones for June were just done by mail.
Okay, gotcha. All right, Mr. Miller?
Yes, sir.
Yeah. Can you tell me why you don't think you should fill out the questionnaire?
Currently, we are currently, Michigan Office of Civil Rights is investigating both the school and the Sheriff's Department and CPS for improprieties that have happened. It's docket number 25-100. And I'm not sure if I'm allowed to get into the specifics of this at this time, but at this point, I am slightly biased towards agents of the county. In 2020, Ms. Cox my daughter was raped in 2019. In 2020, Ms. Cox failed to provide a compelling case to secure a conviction. So I don't believe that I could be an objectionable juror at this point.
Okay. So I get that if it was a criminal case where the government was involved.
It is an abuse case.
Yeah. So that's not the only kind of trial that we ask jurors to serve on though.
Right, but I've seen failures in this court through my daughter, through a criminal case, and I'm in the middle of a civil case in which I have become quite biased because CPS and the Sheriff's Department have been used retaliatory against us, circumventing our Fourth Amendment rights, circumventing our First Amendment rights. And this is using agents of the county. And I do not believe that I could be objectionable at this time.
Okay. And again, I get that if it involves, county officials and so forth. But again, not every case that we ask jurors to sit on has anything to do with the county or the government or anything else. Sometimes it's contractual disputes between parties.
And that is another issue that I'm having.
Let me finish telling you before you give me off, before you try to cover every single possible thing that you would have to serve as a juror on. There are disputes over contracts. If there's an accident or medical malpractice, there's disputes over damages. So we ask jurors to decide liability, in other words, whether someone is at fault for an injury or for breaching a contract, and then what the damages should be for that. And so none of what you're telling me would be a basis for you to not be able to sit as a juror in one of those cases.
Also, MCR, Michigan Office of Civil Rights, is compelling us to go through civil mediation prior to any filings with the, in federal court. Because part of our argument is that they failed contract law of upholding a IEP.
Okay, so again, that would have no bearing on your ability to be fair to two private citizens who have a dispute amongst themselves that the government's not involved. So.
I mean, but can the jury, when jurors are called, is it called by numbers to fill in the place? And then I would be, once again, if it's a criminal case or a civil case involving the sheriff's department, I'm not going to be an object.
Yeah, so I don't know what kind of case you would be called on, and jurors are picked at random. So again, there's no reason why you shouldn't fill out the questionnaire and be called to jury service. And if you're called up to the jury box in a case like that, you can tell the lawyers why you think you would be biased, and you may be excused. But
I'm pre-biased, Your Honor. I've become biased. Once this is settled, I would like to sell my house in Crawford County and be done.
Yeah,
I'm
none of that is a reason for you to be excused from appearing and explaining why you're biased to the lawyers. And depending on the kind of case, they may excuse you, but depending on the kind of case, they may not. So what you're telling me is not a reason for you to be excused from jury service in general, or a reason for you to not fill out the questionnaire. So I am going to ask that you do that before you leave today.
I will fill it out, but I will write objection on all of the answers.
Okay, you need to fill out the information that's requested. You can't just write in objection for every answer. You need to put the information that's requested on there.
All right, Your Honor, you have a wonderful day. I'll fill this out.
Okay, thank you. I appreciate that. Does anybody else have any questions about your service as jurors, or your need to fill out any questionnaire? So, for your, I kind of already explained it to Mr. Besselmiller. I'm sure you've just heard what I just said, but jury duty is a very important part of the court. It's one of the few civic duties that members of our society are asked to perform, are obligated to perform. It's an important part of the court because for all the complaints and knocks that our system gets, it's the best in the world when it comes to, at least to criminal cases, because in other countries and under other systems, if the government or a prosecutor or the police think that you're guilty of a crime, all they have to do is make that allegation. In our country, in order for you to be guilty, the state or the police or the prosecutor have to convince 12 of that person's fellow citizens that they're guilty. And if they can't do that, then that person is not guilty. And as jurors, you have the ability and the obligation to be a check on the government, to say to the government, if you can't prove that my fellow citizen is guilty of this crime, then I'm going to say not guilty, and you cannot take away that person's liberty. So acting as a juror is an important way that you can participate in the government, an important way that you can make the government do their job, and to protect yourself and your fellow citizens from overreach. So in the criminal context, it's incredibly important. In the civil context, it's also important because in medieval times and before that, when citizens had disputes, they dueled each other and shot at each other, or they fought with swords or whatever it was. Now we have a system where if you have a dispute with your neighbor over something, or somebody wrongs you in some way, you don't resort to physical violence. You sue them, you come to court, and you ask jurors to find that that person is responsible for the injury to you and to award you damages. So in the civil context, jurors provide a peaceful way for all of us to resolve our disputes amongst each other. So it's incredibly important in the civil context as well. So I say all that because I want each of you to know that we're not just making you come in here because we don't like that you didn't fill out the questionnaire. We're making you come in here because you need to understand that this is an important duty that makes a difference to all of us in our community, including yourselves. And And that's why we're forcing you to come in here. We did make efforts to get all of you to come in without having to be personally served. For whatever reason, that didn't happen, so the county did have to expend resources to personally serve you, to have you come in. So for that, we're gonna ask you to reimburse $25 to the clerk's office for the cost of having the personal service carried out. So anybody who was personally served needs to make arrangements to pay that. If you weren't personally served, I'll just ask them.
Just two of them. That would be Ms. Miller, who was personally served for failing to appear on May 12th, and then Mr. Vessel Miller.
Okay, so.
Your Honor, may I address that?
Sure.
Prior to the date of the questionnaire, I had contact with the office, with the clerks, letting them know my situation. And, you know, I did let them know that I was going to show up for any potential date, that they didn't need to serve it. And now I'm hit with $25. You know, part of my case that is going on is that the county, in particular CPS, targeted us for being low income. So another $25 out of my wallet while I'm supporting two kids in this inflation where I haven't had a raise is taking food out of my kids' mouths.
Okay, did Mr. Vessel Miller contact?
He did. He talked with me, and I instructed him that he needed to complete the questionnaire. And I couldn't help him. I was the only one that could address his issues with if he was to talk to the judge, because he refused to complete it.
Okay. Did he indicate that he would appear and stuff?
He said he would be here to talk to the judge. Yes.
Oh, all right. So I'll waive that with regard to Mr. Vessel Miller. And then, sir, again, I'm just going to ask that you fill out that questionnaire.
Doing that right now.
Okay. All right. Thank you all for being here today.
Judge, the other ones were because they missed jury duty.
Okay. Yeah.
4 of them.
Okay. So I'm not going to impose any additional fines on anybody. I think those of you that have appeared here today, you know, it's taking time out of your day. I'm sure that's penalty enough. And so I just look forward to seeing you all here for jury duty the next time you're called. Thank you.
We have 4 absent. Are we going to do personal service for those?
Yes.
Okay. And the ones that did not show after personal service for the questionnaires?
I'm gonna have to decide what to do about that.
Okay. I suggest talk to Judge Hunter. He does a PR bond. Once they complete the questionnaire, they're free to go.
All right. Thank you. Yes.
Sir, I've served on 2 juries. I filled out my questionnaire. And I believe the ice storm was responsible for me not receiving anything after that. If you look at the date on the, I filled out the questionnaire, never heard anything else, didn't assume anything until I got this.
Okay.
I never received anything else.
Okay. What's your name?
Samovitz, Marcia.
Is
Number 1 on the June, she missed the June trial date.
But I've served, I don't shirk my civic responsibilities. I've been on 2 juries in 3 different counties.
Okay.
So I believe it was the ice storm that screwed me up, not receiving any mail.
Okay. Do we have your current address?
Yeah, it's all the same.
Okay. So again, I think probably the issue, obviously you haven't been shirking your civic duty. You served on 2 juries before, so I think maybe that was, you know, you didn't receive the notice and that's why you weren't here. And so when, and we obviously didn't know that until you're telling us now.
I didn't have power for over 2 weeks, let alone mail, so I probably. Yeah.
So, yeah, I mean, I guess the reason why you were asked to come here today was just to tell us why you didn't appear, and I certainly accept that explanation. And as I indicated with the other folks, we're not going to impose any additional penalty on you. I appreciate you raising that, and I appreciate you having served as a juror
Scared the
twice.
heck out of me when I got this.
Yeah. So thank you for being here today. Okay, thank you. What that badge represents, I'm swearing. Mr. Carey, were you anticipating your client appearing today?
No.
Okay. I just have one other individual here that I can't identify. I want to make sure it's not connected to this case. The person who's, ma'am, can you tell me your name under PMR there?
April White.
Miss White. Okay, we're going to take your hearing in just a minute, so I'm going to put you on hold for just a second. Okay, we're on the record in Lafitte versus Shalagi. This is file number 2511879. Mr. Carey, you're here on behalf of the plaintiff. This is your motion for entry of a default judgment.
Yes,
is there anything you'd like to present by way of argument here in support of it?
As briefly as the court will allow, this is an action to quiet title. Title search revealed a possible interest in the subject property as identified as the defendant in this action. We were unable to effectuate personal service over the defendant. We sought and received an order to answer. We published and posted. The time frame for filing an answer has passed, and we have not in any way heard from the defendant, and accordingly would move for entry of judgment.
Okay, I had a chance to review the file prior to today's hearing. There was proper service by way of motion and order for alternate service in this case. And the motion for default judgment is properly before the court as no one has come forward to answer the complaint or otherwise defend. This hearing was set for 2:15 today. It's now 2:25. No one has appeared here in the courtroom or by Zoom to contest the relief requested. So the court finds it would be appropriate for entry of a default judgment. I did get your motion, but I didn't get an order, and I don't see one here in the file.
It probably doesn't do you much good for me to show you one on the screen, does it? I have one, but doesn't mean it got to you. We'll send one over before your right now to the court and have it there for you.
Okay, based on the record we've made, I will sign that order once it's presented. Anything else I can address for you today?
Thank you, Judge.
Bill, are you emailing that to me or are you bringing it physically?
My strong preference would be to email it to you.
Okay.
Is that all right?
That'd be right.
That's fine.
Yep, that works for us. If you want to send it to me, and I will get that to him.
Coming right over. Thank you so much.
Thank you.
Okay, thank you. You're free to disconnect.
Thank you, Judge.
We'll go on the record in White versus White. This is file number 2511858. The record should reflect that both parties are present today. Ms. Robinson, are you appearing on behalf of the plaintiff in this case?
A defendant, Mr. White.
Defendant, Mr. White, okay. And I do, or I am in receipt of a proposed consent judgment of divorce. Is that how you wanted to proceed today?
Yes, Your Honor.
And Ms. White, did you want to proceed with finalizing the divorce today?
Yes, sir.
Okay, so Mr. and Ms. White, if you could both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. And Ms. Robinson, I know you're representing the defendant. Did you want to take the proofs from him? It doesn't really matter, obviously, for purposes of the statutory proofs.
I can take the proofs from my client. Yes, Your Honor.
Okay, thank you. Please proceed.
Good afternoon, Brian. Please state your full name for the record and spell your last name, please.
Brian James White, White, White.
Are you the defendant in this case?
Yes,
At the time this petition was filed, had you been a resident of the state of Michigan for 180 days and lived in Crawford County for at least 10 days continuously prior?
yes.
Where were you and the
Or,
plaintiff
excuse me,
married?
I'm sorry, it's Gladwin County.
I apologize, that's correct. The plaintiff lived in Crawford County. Excuse me, Your Honor. I may have taken, at the time of filing was plaintiff a resident of Michigan for 180 days and lived in Crawford County for 10 days previous?
As far as I know, yes.
Okay, thank you. When and where were you and the plaintiff married?
What's that? I'm sorry?
When and where were you and the plaintiff married?
Beaverton, August of 9th, what is it, 2023?
Thank you. When did you and plaintiff separate?
November of last year.
Okay. Would you say there has been a breakdown in the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Unfortunately, yes.
To your knowledge, is plaintiff pregnant?
No,
Were there any minor children born or adopted to you and plaintiff during the marriage?
no,
Have you reviewed have you reviewed the proposed judgment of divorce, including the property division terms?
yes,
Do you consider it fair and equitable under the circumstances?
yes,
Did you sign a consent judgment of divorce?
yes,
Are you seeking spousal support?
no,
Do you understand that if you waive spousal support today, you cannot later come back and petition the court for spousal support at that time?
correct.
Are you asking the court to grant you a divorce and enter this judgment today?
Yes,
Thank you. Your Honor, I believe the proofs are sufficient from the defendant.
All right, thank you. Ms. White, did you hear all the questions that were asked of Mr. White?
I did.
Did you hear all of his answers?
I did.
Do you have any reason to believe that any of the answers he gave were untrue?
No, sir.
At the time of the filing of this divorce, had you lived in Crawford County for at least 10 days?
Yes, sir.
Are you currently pregnant?
No, sir.
Under the divorce judgment here, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and you would not be able to come back later and ask the court for that?
Yes, sir.
And I see that there is an electronic signature from you dated July 23rd, 2025 on this judgment. Did you in fact submit an electronic signature on that day? I'm sorry, you broke up. Could you repeat that?
Yes, sir. I did. Yes, I did.
Okay. And prior to signing that, did you read through that proposed judgment?
Yes, I read the whole thing.
Okay. And in signing that, does that mean that you agree to and will abide by the terms of that?
Yes.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties. The court has reviewed the proposed judgment, finds that it is equitable and contains all the provisions required by statute. I've signed that judgment with today's date. Ms. White, are you asking to have your last name changed?
Yes, sir.
Okay, so because your divorce is final as of today, that means that your name will be changed legally as of today as well.
Okay.
So you'll need to make sure that you change your identification in other documents, okay?
Yes, sir.
Ms. White, did you have any questions at all for me?
I do not.
Ms. Robinson, was there anything else that you needed to address on the record today?
No, Your Honor. Thank you.
Okay, thank you. That's all for this hearing today, and all parties are free to disconnect.
Thank you.
All right, sir, at the jail there, can you tell me your name, please?
Brandon Peel.
All right, we'll go on the record in People versus Brandon Michael Peel. This is file number 2518108. The record should reflect Mr. Peel is appearing today by video from Crawford County Jail. If I could have counsel put your appearances on, please.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, duty attorney for Brandon Peel.
Okay, Mr. Thompson, have you had an opportunity to speak with Mr. Peel?
I did speak with him, Your Honor. I still haven't received anything in writing about what the alleged bond violation is here.
Okay. I have it. Let me see if my staff can send it over to Mr. Thompson.
I was verbally told by district court staff, so I did discuss what I was told with Mr. Peel, but I do want to make sure there's something in writing in the file.
You're sending it right now, Mr. Thompson.
Okay.
It looks like the violation was entering into a place where he was not. Is that right?
Yeah, it was contact with the protected party.
Okay.
And was that Tuesday? Is that the allegation?
Yeah, the date listed is August 5th.
Okay. So if the court has that in the file, I see.
It is reflected in the file.
All right, I think we can go forward.
Okay, how does Mr. Peel want to proceed today? Does he want to admit the violation or have this set for a bond violation hearing?
He indicated to me that he wanted to plead not guilty and have the matter set for hearing.
Okay, so the court will set this for a bond violation hearing in front of Judge Burmeister. That will be set for hearing on September 30th of 2025 at 9 a.m. Mr. Peel, you will be given written notification of that date, so you don't have to remember that. You'll be given some paperwork that tells you that date and time. And then in terms of Mr. Peel's status between now and then, Ms. Coe, obviously we've got an alleged bond violation here. What's your position going forward pending that hearing?
He does not have very much criminal history, but all of his criminal history involves his family. They're all domestic violences. He has a 2010, 2012. He may have one that was deferred in 2007. It's not really clear from the CCH. And then there's one in 2013 where there's no segment. I don't really know what Mr. Peel needs to understand. There was no violence, but he just doesn't seem to get the court order. So I defer to the court on how they want to handle this. He has some mental health issues. And this involved his mom. And he just seems to struggle with understanding what he can and can't do. So I would just defer to the court. I'm not really sure what to do with him here.
Okay, Mr. Thompson?
Yeah, Your Honor, in speaking with Mr. Peel, he identified with me that he does have some mental health concerns and he is considering or requesting or maybe in need of some hospitalization. He's received hospitalization in the past. he advised me that he's not up to date on some injectable medication that, may help him feel healthier and in a better position. So I've talked to him about reapproaching with CMH and trying to get on board with services again. That might help him if there is prescription medication that he needs, and so I'd ask the court to reinstate a bond, and then perhaps if with continuing work with CMH or the hospital here, we can get him a better placement than the jail. That might be what ultimately at the end of the day he needs.
Okay, so I'm gonna continue the bond that was previously posted. I'm not gonna require Mr. Peel to post any additional monies for bond to be released. I am going to, I was just looking at his original bond paperwork, and it does contain the no contact provisions. But I'm going to add a provision in there that he has to participate in and comply with any mental health treatment that's recommended to him by CMH as a condition of bond, as opposed to just being something recommended. And I'm going to write that in. And then again, we'll set this for hearing on September 30th. Mr. Peel, do you have any questions at all?
I am to get into contact with CMH.
Yes, exactly.
Okay.
And more importantly, Mr. Peel, you need to comply with all the provisions of your bond conditions. That includes the no contact provisions. If you continue to have contact, you're going to be arrested again, and it's unlikely at some point a bond's going to get set high enough that you're not going to be able to get out of jail. You're going to have to spend time in jail until your case is resolved. So it's in your best interest to follow these conditions. Okay.
Okay. Yes, Your Honor.
All right, Ms. Polk, anything else we need to address in this file today?
No, thank you.
Mr. Thompson?
Nothing further for today's record. Thank you.
All right, thank you. And then Mr. Peel, is somebody from the jail there with you, a corrections officer?
Just outside the door, I can step out, get somebody real quick.
Yeah, let them know that we're ready for the next person, okay?
Okay.
Thank you. All right, sir, is your name Ryan Hart?
Yes.
Okay, we're on the record in People versus Ryan Hart, two files, 21-15985-ST, 21-3944-593-SI. The record should reflect that Mr. Hart is appearing today by video from the Crawford County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, duty attorney for Mr. Hart. Your Honor, these allegations arise out of missing a hearing that was on May 6th, 2025. Mr. Hart advised me he was lodged in the Newaygo County Jail. I had a chance since we got the show cause and the paperwork. My office has called the Newaygo County Jail. They confirmed to us that he was lodged from April 11th, 2025 through July 9th, 2025. So would respectfully advise the court that he was lodged on that date of that hearing that he missed in May, that would be good cause to dismiss the bench warrant. In terms of the underlying matter, I don't have the court file. Mr. Hart believes he had earlier paid a bond that could satisfy his outstanding fines in this matter, and I'd ask the court to consider forfeiting that bond and closing this file. Thank you.
You know, I would defer to the court. I think that seems like a fair and reasonable.
Okay, so I'm looking at the file. I have.
I cannot judge.
There's 2 yellow receipts in these files, and I apologize to counsel. I'm not used to looking at interpreting the information in the district court files, but it appears to me these look like receipts to me for bond money that was posted in each file that would cover the amounts that Mr. Hart owes on each file. So in my view, if the court were to order that those be applied, then there wouldn't be anything further for Mr. Hart to need to do.
That is what we're requesting, Your Honor. Obviously, that bond money is held essentially in escrow right now, so his fines are still outstanding, but we are asking the court to forfeit those bonds, apply them to his fines, and close the file. And I would agree with the court, those yellow receipts in the file do reflect monies that are actually on deposit with the court.
Okay, so that's what the court's going to order. I think that's an appropriate resolution because Mr. Hart was lodged, and I accept the representation of counsel having confirmed that with Newaygo County. The court will dismiss the bench warrant and will not impose any additional penalties on Mr. Hart for his failure to appear, given that he was incarcerated and would not have been able to appear. And then the court will order that the amounts currently held on bond for Mr. Hart will be applied to each of those files, and the court will order that those cases be closed. Mr. Hart, do you have any questions about that?
No. Can I go?
Ms. Coke, anything?
No, thank you.
Okay, so Mr. Hart, there's probably some paperwork that I'm going to need to sign here, and as soon as I do that, you'll be released. That'll happen before the end of the business day today.
Thank you. Thank you, Tom, Jason.
All right, thank you. That's all for today on those 2 files.
Thank you.
All right, bye, gentlemen.
Mr. Thompson, I'm going to just have you remain on the line. I have counsel on the next case here.
Certainly, Your Honor.
I'm done, right, Your Honor, until 3:45?
Yes.
Okay.
Okay, Ms. Mott, are you able to hear me okay?
Yes, Your Honor.
All right. And Ms. Mott, your client is connecting. Mr. Thompson, are you anticipating your client being present?
I'm not sure, Your Honor. I don't believe she's necessary since I don't believe we're taking testimony today.
Okay, so we'll go on the record in Coppernell versus Patricino. This is file number 2311369. Both counsel are present by Zoom video. The record should reflect the defendant is also present by Zoom video. Ms. Mott, this is your motion in limine. I had a chance to review your motion and the documents supporting that. You're essentially, I mean, and correct me if I'm wrong, but what I get from your motion is Ms. Coppernell's asking for amounts that would have to be divided from the proceeds of the sale to be reduced by alleged damages that Ms. Patricino allowed to happen to the home. And through the course of an evidentiary hearing, the court would do that. You're asking the court to also include amounts for damages that Ms. Coppernaw would have caused to the home prior to the parties entering into the judgment. Is that correct? I'm sorry, you weren't coming. Your audio is very, very choppy. No. It sounds like maybe your microphone, it's a problem with your microphone. I'm hearing your voice, but it's really, I can't understand what you're saying. Unfortunately, I can't even tell what you're saying right now. If you want to try and connect with a different device or even just on the phone, we could try that.
Sometimes it helps if you get a lot closer to the microphone. Sometimes that distance to the microphone really distorts the signal when it goes then across the Zoom.
That did not help. So let's try a different device, maybe. Waiting. I didn't get a job. And then we did check. Okay, Ms. Knott, do you want to try it again?
Yes, can you hear me?
Yep, that is much, much better.
I very much apologize. I even prepped it ahead of time and it was working, so I'm very sorry, to the court.
That's okay. That's
Your Honor,
of technology. Go ahead.
Thank you. Your Honor, the issue is, as you asked a moment ago, is that you issued a judgment on April 29th, 2024, in which you ordered that the property was to be listed for sale and that the proceeds were to be divided equally. Then, as you'll recall, in November 7th of 2024, there was another order that specified the terms of how that sale was to happen. My client abided by that order. There was her attorney died. Then she experienced the roof leaking and had to get it repaired and got it relisted. And my point is there were 2 show cause hearings held in which the court was able to hear the issue, was able to hear evidence and testimony, and those issues, that's since resolved. So now to open the door again and limit what is going to be heard was already at issue before the court as far as how proceeds were to be divided, then to go back and say, oh no, that we want to shake at it now because we've picked up more of the expenses when there was no consideration to those expenses pre-judgment. So my argument is that it isn't fair and just to have this moment in time and then have so many things happen after the fact, some of which are completely out of my client's control, and then just say, okay, but we're only going to consider mortgage payments that you made. We're only going to consider, these expenses when none of those got considered pre-judgment. So to me, that's because the plaintiff then started making payments outside of any court order, then why does she now get credit? Why wasn't, that was a decision she made, and my client made payments pre-judgment. So to me, that's a moot issue. I understand there could be some attorney fee claim, but that's not before the court. There were 2 show cause motions. There were 2 show cause hearings. There were no orders holding the defendant in contempt. In my eyes, what's before the court has already been resolved. And to continue to do litigation that's expensive and time consuming to the court and expensive to these ladies, we're just prolonging something that the court already ruled upon. Thank you.
Okay, Mr. Thompson.
Thank you, Honor. I mean, obviously, number one, I do think there's a rational basis to limit claims to post-judgment because it's post-judgment. The parties compromised and took their, various claims for expenses or equity, and that's all reflected in the judgment. As counsel noted, that's a judgment from April of 24. The house was supposed to be sold. My client was supposed to be satisfied last year. The court's familiar with the several hearings we had that compelled Ms. Patricino to ultimately sell the house. The house was ultimately sold. I'm very pleased that occurred. The sales proceeds are in escrow. My client is going forward with this. This hearing's been scheduled since before the sale. She wants to pursue her damages for her allegations that the defendant failed to comply with this court's order. So in terms of whether at that hearing damages should include pre-judgment claims, I don't see any basis for including pre-judgment claims. Counsel may well have a defense to this idea that to our claim that Ms. Patricino intentionally violated the court's order, and they may have a defense to the amount of damages, but I don't believe they get to relitigate pre-judgment claims in the process. So as to pre-judgment claims, I think those are appropriately barred as to both parties. We are requesting to go forward with our post-judgment damages that we allege were caused by the defendant's failure to list the home, the failure to keep the home in good condition, and the failure to comply with this court's orders. So that is our position. Thank you.
Thank you. Ms. Knott, what's your response to that?
My response is that there's no vehicle with which the plaintiff put those allegations before the court. There's been no filing of something making those claims. There's been motion to show cause, which had hearing and were resolved. So I think number one, there's no vehicle where that's properly before the court. And number two, I think, again, I just don't think that you can reopen the door to damages when they both contemplated that there would have to be a sale. There were going to be ongoing expenses with a home, because they're, until it sells, then they're mutually responsible. So I think that would have been contemplated in any kind of judgment that was made. And I think all issues are resolved before the court. The court should stand by the judgment, which says split proceeds equally, and move forward. Thank you.
Okay, all right. I'm very familiar with this case. This has been going on for a long time here in terms of trying to get this finally resolved so that everybody can move forward. And it's been an interesting road that we've been down so far. Unfortunately, Ms. Patricino's previous attorney, Mr. Leonardson, passed away during the course of the representation. And then we had a couple court hearings where the court's primary goal at those court hearings was to get things resolved and get things moving. And the show causes were filed based on allegations that Ms. Patricino was not cooperating with the sale of the property as the court had ordered in November of 2024. So the way I see it, first of all, with regard to any of the pre-judgment issues, I mean, I agree with Mr. Thompson. The parties entered into that judgment in April of 2024. Everybody started from ground zero at that point, as far as I'm concerned. I mean, had the sale happened on that exact date, then everything would have been divided equally and nobody could have claimed, well, wait a minute, something happened before we entered into this judgment and I want to adjust the distribution of the funds based on that. So I agree that, that judgment cuts off any claims that either side would have had prior to that judgment being entered into for anything that the other party did to cause damage to or otherwise diminish the value of that property. So everything is going forward. Ms. Mott, I think you raise a very interesting question from a procedural standpoint, because we did have several show cause hearings. The court never did find Ms. Patricino in contempt. And I think had there been a contempt order issued, then there would have been no question really that there would have been a finding of record that Ms. Patricino engaged in some kind of misconduct or some type of willful failure to obey the court's order without good cause. And so then there would have been that finding on the record that the plaintiff could then rely on to say, hey, this didn't happen, you found her in contempt, we want damages based on her non-compliance. And I think there would have been a basis for that, obviously, in the court's power to issue damages for compensatory damages for contempt or arising out of contempt. But, and Ms. Mott, you weren't part of those hearings. I don't know if you got the transcripts or reviewed the record from those hearings or not. But, what really happened at those hearings was, and I think I told Ms. Patricino this on the record, that I felt that she was not complying with the order, that she was dragging her feet purposely for whatever reason. And basically at those hearings, I kind of made Mr. Thompson and his client negotiate with Ms. Patricino in an effort to get this resolved. And Mr. Thompson, in response to the court's direction at those hearings, didn't push the issue of asking the court for a finding of contempt. Based on representations that were made by Ms. Patricino, and I wasn't party to those, but after the parties, we took a break, went off the record, I believe at both of those hearings, and the parties had discussions and then came back on the record and indicated how they were going to move forward. So Mr. Thompson, I think at the court's direction, and based on agreements that were made at those show causes, never pushed the court or asked the court for a ruling on contempt. It never asked the court for a contempt finding. So again, I think that puts this in a very interesting procedural standpoint, because I think both parties have a basis here. Ms. Mott, again, I think you make a really good argument that there isn't a finding of contempt here, and I completely see your point, but I also think that Mr. Thompson's got an argument to be made that he didn't ask for a final ruling on contempt because the court, put everybody into a position where they reached agreements, and he could not have foreseen that those agreements were going to result in damages to his client. And so I think he's got a fair basis to argue that, okay, yeah, there was never a contempt finding. There was never a finding that Ms. Patricino specifically did something wrong to violate the order. But the fact is, the sale didn't occur until this particular time. It didn't occur for the reasons that it didn't occur. And I've got a basis to ask for additional amounts for my client based on those delays. So I think ultimately what the court has to do, and I'm using and exercising my discretion here, and in the interest of fairness to both sides and getting this matter put to bed, I think we do need to have that hearing. I think Ms. Mott, you're entitled to make all the arguments that would be available to Ms. Patricino as to why she shouldn't be liable for any of the damages that occurred following the judgment. I think, part of that argument could be that she never was found at fault, and that's a reason for the court not to award damages. And then Mr. Thompson, I think, is free to make the contrary arguments. And then based on those arguments and the evidence that's presented, I think the court then would have to make a determination to whether any additional amounts should be awarded to Ms. Coppernall, whether it should just be divided equally and both parties go on their way, because there hasn't been an adequate showing that something that Ms. Patricino did, either by her delay or neglect or anything else, resulted in a lower value or damages to the home. And I think it's entirely possible that Ms. Mott can, through testimony, establish that there was good cause for everything that happened subsequent to the judgment, and there shouldn't be extra money awarded to Ms. Coppernall. But again, I think the court has to allow Mr. Thompson to make that argument in light of how the case is proceeded, and to be fair to him and his client. But I don't think it's by any means, something that I can say here today that Ms. Mott won't have good arguments for why that should happen. So in terms of the motion before the court today, the court is ruling that no issues occurring before the judgment would be allowed to be argued at that hearing, only matters subsequent to that judgment, and that both sides are free to argue either that something Ms. Patricino did or didn't do resulted in additional damages. So I don't know whether that's denying your motion completely, Ms. Mott, or only denying it in part, but I would ask that you prepare an order that reflects the ruling of the court here on the record today. And Mr. Thompson, did we already have a date for that hearing?
We did, Your Honor. It
It's
had
a-
been adjourned. It had originally been scheduled in June. It had originally been scheduled, even before Miss Mott was on the case. So this is going back some time, but yes, we do have a date for that full evidentiary hearing.
Oh, okay, and that's set for August 15th, so next Friday. Okay, so we'll proceed with that hearing next Friday, as scheduled. We lost Miss Mott. If she comes back in, then I will
Oh,
update her, but Mr. Thompson, anything else we need to address for your side here?
no, I don't
I'm
know
so
if
sorry.
counsel heard the court's direction, so I'm hoping she can come back so we can confirm that.
There we go.
I'm so sorry.
Okay, so Miss
I did
Mott,
not hear it.
we're gonna proceed with the hearing as scheduled next week on the 15th.
Yes, I have one question about your order, if I may.
Yes,
Are we working under the show cause standard? She has to have, there has to be shown a good, what standard of law are we, what vehicle are we moving forward on? Is it a show cause continuation?
that's my view is that this is a continuation show cause. Yes.
I
Okay.
would concur with that, Your Honor. I think this is a continuation of that hearing where Miss Petrosino appeared without counsel before Miss Mott's involvement after Mr. Leonardson, passed away. I think we're continuing that hearing to make an evidentiary record for the court to make a ruling.
Right, yep.
Okay. Good, thank you.
All right, okay, thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Okay, both council are connected, so we'll go on the record at Bay Breeze Farms versus Humblebee Products. This is file number 2511899. If I could have both council put your appearances on.
Certainly. Good afternoon, Your Honor. May it please the court, Jonathan Martone on behalf of the plaintiff, counter defendant, and third-party defendant.
Gary Traskus on behalf of Humblebee Products LLC, third-party plaintiff, counter plaintiff, and defendant. I had to think about that one for a second, Your Honor.
Yeah, me too. Let's just go with names today. That might make it easier. Your parties, your clients' names.
I represent the other guys, Your Honor.
There
I
we go.
represent Bay Breeze Farms LLC and Peninsula Agricultural LLC.
Thank you. Okay, so we're on the record today. We have a motion by Mr. Martone's client to dismiss count 4 for silent fraud of Humblebee's counter complaint. And then we have this set for a scheduling conference. I did have a chance to review the motion and brief as well as the response. Mr. Martone, anything that you wanted to state today by way of oral argument support your motion?
Thank you, Your Honor. And I certainly don't intend to belabor all of the points that we included in our brief, but there are a few salient matters that I want to highlight, particularly in light of what the response provided. You know, we did outline 3 grounds, Your Honor, for this court to otherwise dismiss count 4 that we do believe under any one of those 3, this claim, is fatal and should be dismissed under the grounds of MCR 2.116C8. I'm going to focus really on 2 of the 3. The first, Your Honor, is just standard that the requisite elements to establish a silent fraud claim have not been pled, nor can they be established. And this is really where I want to highlight because of the information provided in the response. Unlike other types of fraud claims, Your Honor, silent fraud requires an affirmative duty to disclose. And that affirmative duty under Michigan law arises really under one of 3 circumstances, either by virtue of a specific relationship, and most commonly in the situation of a fiduciary relationship, or in the absence of that, and the counter plaintiff has conceded that there is no fiduciary relationship, it would only arise in a commercial setting, which we are here between 2 commercial parties, where either a party made specific inquiries as to an issue or otherwise provided particularized expressions of concern that would otherwise basically put the other party, the seller, on notice, and that their silence would then constitute, a misrepresentation through omission. And the third party and counter complaint is entirely devoid, Your Honor, of any allegations that establish a duty to disclose under any of those 3 types of prongs. But really tellingly, Your Honor, and particularly with respect to whether there were specific inquiries, the response from the counter plaintiff and third party plaintiff is actually that marijuana product inquiries would require a specific inquiry of up to 50 CRA listed pesticides, additives, or fertilizers. So basically what they're saying is, hey, we didn't make any inquiries, and because there would be a lot, we'd have to make over 50 of them. Well, Your Honor, inconvenience is not an exception under the law to creating a duty. The law is very clear, and we cited cases going back from the Michigan Supreme Court all the way back to the 1940s even, Your Honor, in a commercial setting, unless there is a specific inquiry with regard to a condition or an issue, or there's a specific expression of concern with respect to that, there is no affirmative duty to disclose. And so for that basis, Your Honor, as currently pled, the claim is fatal. But allowing even an amendment would be improper because under the futility exception, because they've acknowledged they didn't make any sort of inquiries, and that the reason being is that there would have to make over 50 inquiries. The issues here in this case don't involve 50 different allegations. They involve one allegation with respect to sulfur contamination. There was no evidence, and they've not responded and put forth any evidence or intent to be able to establish that there was an inquiry with respect to sulfur contamination, nor did they put forward any evidence or the intent to be able to provide evidence with respect to any expressions of concerns with respect to sulfur contamination. The other big reason why this count should be dismissed, Your Honor, is under the economic loss doctrine. And, we briefed it well and, basically as the court's, I'm sure well aware, it stands for the proposition that where damages and harms arise out of a contract, a party can't maintain a separate tort claim. And that body of law has been applied and examined by the Michigan courts under a number of circumstances. But what I really want to draw the court's attention to are the circumstances in which that body of law has been applied with respect to the contracts for the sale of goods in the UCC. The cases and the arguments that my opposing counsel makes are really distinguishable and in opposite. They apply in settings outside of the UCC and contracts for the sale of goods, Your Honor. And basically the argument that opposing counsel has made is that, well, he acknowledging that there is this contract, acknowledging that the economic loss doctrine would generally apply. His argument is, well, there's really a duty beyond that, and that my harms, I'm trying to plead additional damages. But Your Honor, it's really not the case. The circumstances and the alleged fraud here again is a silent fraud. It's the omission of the supposed contamination levels of sulfur. That goes to the heart of the quality of the products being sold, Your Honor, which is a term and condition of the contract itself. Count 2 of their complaint, which is a breach of contract count, Your Honor, that's their damages. Their damages are, hey, we bought product that we're alleging is defective for the very same reasons that they're alleging, that should have been otherwise disclosed in this. And as I argued, a few moments ago, Your Honor, there is no duty to disclose. They haven't established that, so they can't even establish a legal duty for purposes of the argument that opposing counsel has made that there isn't a duty separate and aside from the contract. The cases that we cited, Your Honor, though, in particular Huron Engineering versus Precision Consulting, which is a 209 Mishap 365, as well as the Sherman v. Sea Ray Boats, are cases in which the Michigan courts have examined the scope and any exceptions to the economic loss doctrine in the setting of tort claims, including even fraud claims, and the UCC. And basically, Michigan law comes down to there's a very narrow exception, a fraud and the inducement exception. However, the nature of the fraud has to be separate and aside from basically the terms and conditions of the contract itself. So had we made a fraudulent representation regarding an intent to, that we weren't going to be sold by a third party, or that a fraudulent representation that, we were going to not swap different types of products or something of that nature, I could see that. But their fraud, their allegations, Your Honor, go to the actual terms and conditions, what they're suing on. They're saying that the product that we bought was defective, and it was defective because they're alleging a unacceptable level of sulfur contamination, Your Honor. And I'm quoting from the Huron Tool Engineering case that when the court was examining this narrow exception, the fraud and the inducement exception to the economic loss doctrine, it drew basically that exception and said, only where the misrepresentations induce a buyer into entering into the contract, but do not in themselves constitute the contract or warranty terms subsequently breached by the seller. And that's at page 375 of that opinion, Your Honor. Again, they're suing on, the basis of the breach of contract term are those exact alleged misrepresentations, the quality of the product being sold. So I do think that the Hearn case cited by opposing counsel, which dealt with an insurance contract, Your Honor, and in fact, the court spoke about the difference of the claim arising out of the general relationship between the insurance agent and the insured and the actual insurance policy versus what we have here, which is a contract for the sale, purchase and sale of goods, a breach of contract claim that alleges these goods are defective, and now a fraud claim that it's alleging that we should have otherwise disclosed the very basis of why they're saying the product is defective, which is this purported sulfur contamination. So it's for those reasons, Your Honor, I do think that this count 4 is otherwise defective under MCR 2.116C8. I think that any amendment would otherwise be futile because they can't establish a legal duty. And I will rely on our brief with respect to their failure to plead with the heightened specificity. And the only thing I would add on that is just a reminder that fraud claims, there's actually a higher, not only heightened pleading specificity, but that the burden of proof is not just by a preponderance of the evidence, but it's actually by clear and convincing evidence under Michigan law. And so for those reasons, Your Honor, I don't think that that claim should stand.
All right, thank you. Mr. Jaskos, your response?
Yes, Your Honor. As far as in response to this, what Mr. I'm sorry, how do you pronounce your last name?
No, it's Martone.
Martone? I was gonna say Martoni, so I wanted to check.
In the home country, it would have been Martone.
Okay. Well, Mr. Martoni is failing to argue or have this court recognize that this is a motion under MCR 2.116C8 based on the pleadings themselves and whether the pleadings themselves taken in the light most favorable to the pleader, my client and myself, that there's just no possibility that there could be absent, even if there's an amendment that could plead a cause of action. Now, I admitted in my response, and then it was, I guess it was derelict on my response, that I should have pled the inquiry itself in the pleadings. However, there were inquiries and an amended response as would be required, I'd be allowed to obtain under MCR 116I5, where it states if the grounds asserted are based on a subrule C8, 9, or 10, the court shall give the parties an opportunity to amend their pleadings as provided by MCR 2.118. MCR 2.118A2 states in part, a party may amend a pleading only by leave of the court or written consent of the adverse party. Leave shall be freely given when justice so requires. Now, there is, in fact, he was gone on vacation. That's why I didn't get a chance to talk to him before I filed a response. That would be the person set forth on the Humblebee employee set forth on the purchase order, Skip Berry. And I asked him if there was any inquiries made of, we believe at that time that we're dealing with, and the sales documents all state that we were dealing with Peninsula Agriculture. We didn't even know who Babe Reeves was at the time. He asked that, was there anything we should know about this biomass before extracting it? That's a problem. And there was no response given to him at that time. Any amended pleading, assuming that we have to sit there, the MCR 2.112 says that's part of the required specificity that must be pled as opposed just that proved at trial, is that we would include that in count 4 of our first amended complaint, in that there was a inquiry that went to if there was something wrong with the product for our reasons of extracting the product and processing it. There was no answer. That we believe would satisfy what we believe is the only one possible absence in the specificity of their MCR 2.112. Now that would then in itself, contrary to what Mr. Martone would have you believe, that there wouldn't have been a specific inquiry regarding sulfur, and that was my response that he quoted as if there that we would require all the other types of 50 different pesticides, sulfur, or fertilizers that might have been included in the grow of the marijuana product. And again, it was a marijuana product that was frozen at the time we bought it, frozen at the time we processed it, so it wasn't available either for washing or for testing. And that would have been common industry knowledge known to Peninsula Agriculture at the time we purchased it, that there should have been a disclosure that there was sulfur, and there is some viable reason for using sulfur, and that goes as to suppressing or remedying mildew on the marijuana product, but that there was an extensive amount used. Now, whether it was, smoke induced or by burning the sulfur, or whether it was a spray application. We don't know. We're just starting this litigation. We haven't had a chance for any discovery. However, we believe that there was a separate duty established once that inquiry was made under the case law, even cited by Mr. Martone, that they'd be honest and there'd be a duty of fair dealing with us to respond and give us an answer as to that there was marijuana, there was sulfur used in the grow of the marijuana. And if we had known that, it certainly would have changed our desire to purchase the product, and or how we would have processed it, because we could have then remedied, even if we did buy it, we could have purged the sulfur off of the product. So it was a key and a customary in the industry issue that should have been addressed, especially in reference to the inquiry made by Mr. Perry of the seller. Irregardless of who the seller was or who we thought we were dealing with, or what the relationship might be between those parties. So we ask, I guess we ask if it's this court's opinion that we should have pled it as opposed to have been a requirement to prove at trial for the trier of fact, then we should be allowed to amend our pleading as to count 4 to show the inquiry that was made.
All right. What's your response to the economic loss doctrine argument?
Well, that again, it would be the separate duty. The duty that would be imposed was once the inquiry was made, because then that was in response to the inquiry, and dishonesty and misrepresentation by omission of what the product was. So that in itself would be a separate court, as opposed to whether it had been in the contract itself, whether it had been they would have given us the wrong marijuana, they would have shortchanged us on the marijuana. There was a separate duty once the inquiry is made to disclose the problem or the fact that sulfur had been applied, and to what extent the application was involved. So the separate duty, as I quoted the one case that gives rise to that, it says it's a separate and an independent duty not to deceive the other party, which is a duty imposed by law as a function of the relationship of the parties.
All right, thank you. Mr. Martone, any response?
Well, Your Honor, I will say the cases I cited, you come after. He's relying on the Hearn case, a 1987 case, again, that's not analyzed in the UCC. The cases I cited, Huron Tool Engineering and Sherman and Sea Ray Boats, Your Honor, are on point in that respect. They've done that analysis. They're subsequent to that decision. They've parsed down what the narrow exception to the narrow fraud and inducement exception to the economic loss doctrine is. Opposing counsel is not doing that granular level of analysis here, Your Honor. Again, the courts have wrestled with this issue because the nature of what he's alleging, the fraudulent silent fraud is, because it goes to basically the quality of characters of the goods sold. Michigan law, and particularly the Huron Tool case, Your Honor, has basically said that's not within the exception, the fraud inducement exception to the economic loss doctrine. And again, the court spoke about and analyzed why it would be concerned that contract claims would be drowned. This is from the court's language. Contract claims would drown in a sea of tort, but for the court's gatekeeping here, and there had to be something more. So in some respects, he either gets count 2 that alleges breach of contract, or he gets count 4 that alleges silent fraud. But these are basically the same issues argued, and he's not, unlike in other areas where you can plead in the alternative, you can't in this instance under UCC law and under Michigan law, when there's a binding contract, which they've acknowledged, and then you're also trying to allege a tort claim, specifically fraud.
Okay. I'd like just to respond to his fact that the cases I cited were before I call it the M&D case, but it also was the basis for the Michigan Supreme Court decision in Cooper versus Auto Club Insurance, which was a 2008 case, which was after. And I believe the other case was in Huron Tool was in 1995. And so therefore, it has been used since then after the fact that there's a separate distinct duty in a contract situation to have honesty, and that there's a separate duty not to deceive the other party.
All right, okay, thank you. Again, I did have a chance to review the brief submitted by the parties and the law that was cited by each, as well as the file generally. The arguments of counsel here on the record today have been consistent with their arguments set forth in writing. So the court feels comfortable ruling on the motion from the bench. As both counsel have acknowledged here for the record, the motion was brought pursuant to 2.116C8. That is arguing that the plaintiff, in this case Humblebee, as a counter plaintiff, has failed to state a claim upon which relief can be granted. The court is to look only at the pleadings and any documents supporting those pleadings, not to make any factual determinations. The court must view the motion in the light most favorable to the non-moving party. If the claim is so clearly unenforceable as a matter of law that no factual development could possibly justify recovery, then the motion to dismiss a claim under C8 should be granted. It's also proper where a moving party can show that an essential element of the non-moving party's case is missing. In this case, looking at all the arguments of Babe Reese, the court finds that the most compelling argument is the economic loss doctrine argument. And as Mr. Martone has correctly stated, economic loss doctrine is proper where a party has brought an action in tort, where there is a contractual agreement in place, and where there is not, or unless there is not, a duty that's separate and distinct from a contractual obligation, then tort claims cannot be maintained. There are some very limited exceptions to that, as indicated by Mr. Martone. One of those is fraud and abuse, and I believe that's really the only thing that would apply in this particular case.
Judge, I'm sorry to interrupt.
Yes.
You're breaking up. I don't know if Mr. Martone can hear you, but you are breaking up on my side. I couldn't hear you for a while.
I could hear you. Your Honor.
Okay. I'm not sure. I can go back a little bit. Mr. Traskos, I want to make sure that you are able to get the court's ruling here. So anyway, the first part I went through the standard under C8. I've just gotten to the start of my substantive part of the ruling here, which is that I do believe that the economic loss doctrine applies in this case. And again, that's a situation where a party has pled an action in tort, and there is a contractual agreement in existence. And unless a party can show that the tort is based on a separate and distinct duty outside of what other party is required to do under its contractual obligations, then that party's sole remedy is in tort with some very limited, is in contract with some very limited exceptions. The first thing that struck me as I read the counter complaint in this case and the arguments of the parties is, and I think the court has to look at the complaint as a whole when interpreting any particular claim made within that complaint. And it's clear that the claims here arise out of a contract between the parties regarding the sale of a product by two parties involved in the commercial sale and production of that product. And so this isn't a situation where you have a private party and a commercial party where there are unequal bargaining positions. Both parties come to this on equal ground. And it's clear to me that the claims really do here in my view, sound in contract. And I say that because, again, I think it's important to look at the overall claims. They're all based on this contract for the sale of marijuana. And so the court finds that generally the claims here sound in contract. And the court, although I think it's intertwined with Mr. Martone's argument that that there isn't or plaintiff hasn't pled a duty, even if we look at this just as a tort claim, but certainly that they haven't pled a duty that's separate and distinct from Bay Breeze's obligations under the contract. And in essence, the tort claim, as I read it, is alleging the same thing that the breach of contract claim is alleging, which is we contracted to receive this product, we paid for a product, it wasn't what we thought it was going to be, and so we've been wronged. And so in my view, when I read the tort claim, the silent fraud claim here, it really does not allege a duty separate and distinct from what Bay Breeze was required to do under the contract in the first place, which was deliver a product that was up to what was required by the contract and the expectations of Humblebee, to the extent that Humblebee can show that those were the expectations. So I don't see a separate and distinct duty. I think the fraud and the inducement exception is an appropriate exception. And when you read the case law involving that, it's because those are representations and fraud that occurs prior to the entry into a contract. And when you look at the elements of fraud and the inducement, involves material misrepresentations that were relied upon by the other party in entering into a contract. And that's not what occurred in this case. There weren't any material representations made regarding this. And the allegation is that Bay Breeze didn't disclose something that they should have disclosed. So it's not a situation where Humblebee, I think, can't make out a claim that they somehow relied on some misrepresentations and made by Bay Breeze, and therefore they should be entitled to some tort damages for fraud in addition to any breach of contract damages. So I find that the economic loss doctrine does apply in this case, that count 4 is essentially a count for breach of contract, in that Humblebee did not receive the product that it believed it should have received under the contract. And so the court will grant the motion for summary disposition pursuant to C8 as to count 4 only. And I don't find, although MCR 2.116 C8 does require the court and speaks in terms of must and shall allow a party to amend, unless that would not be justified. And in this case, again, because the court finds that economic loss doctrine applies and tort remedies are not available, that amendment would not be justified. So the court is granting the motion. Mr. Martone, I would request that you prepare an order that reflects the ruling of the court today, and just put for the reasons stated on the record.
Certainly, Your Honor.
And then we do have the scheduling conference in this case. Mr. Martone, on behalf of plaintiff, can you tell me kind of the status of discovery so far? And if there are particular timeframes that you would like to request the court to put in place?
Certainly, Your Honor. No formal discovery has been commenced, although both parties have exchanged their mandatory initial disclosures. We just yesterday, the due date, filed our basically responsive initial disclosures with respect to the counter complaint and third party complaint. So I do believe now the parties under the court rules would be in a position to actually commence discovery. So I'd ask the court just to set perhaps a typical scheduling order discovery for 90 or 120 days. I'm not sure what would work for Gary or the court's pleasure, but and perhaps order the parties to mediation at the close of discovery or at any point therein, and perhaps set a pretrial conference after that point.
Mr. Traskos?
90 to 120 days is fine with me. The question only becomes then we can get it done, but if there's, trouble scheduling and things like that for depositions, and so there might be additional need, but we can address that at the end of discovery. The question I have is with Mr. Martone, is when you said mediation, are you saying case evaluation or mediation?
Facilitative mediation.
Okay.
It would be, I've always found it to be effective, and particularly in a case where I don't believe that the parties have had any discussions. It's just they went radio silent as of the fall. So perhaps having someone bring parties either together physically or virtually to try to work out a resolution would be helpful and meaningful. But I don't know if you think that you need to get certain discovery done before that. I mean, from plaintiff's perspective, we have, it's just it's a straightforward breach of contract type scenario. So it's dollars and cents. So I think, we'd be willing to mediate really tomorrow even. But I certainly respect that there might be discovery that you feel that you need to get done before your clients would feel in a position to mediate a case.
Well, to be honest with you, we felt we had a contract with Peninsula Agriculture, and now you're telling me it's Bay Breeze, and we never even talked to Bay Breeze. So I guess there's that issue I've really got to delve into and understand what's going on between those parties. And 90 days would take us kind of toward the end of November, and December usually is a pretty hard to schedule month and kind of a dead month to be.
Sure.
And so I have no problems with the 90 to 120 days, but I would prefer case evaluation when I have the opportunity to understand exactly what all the facts really are. And
All right, so, well, here, this is what we're gonna do. I'm gonna set discovery for 120 days. I'm gonna order mediation to occur within that period of time. There is, in the pretrial order that will go out to both of you, there is instructions which start with the two of you conferring to see if you can agree on a mediator, and then notifying the court of that. If you can't agree on a mediator, then there's a procedure in that pretrial order for the court to select a mediator. Case evaluation is something that I typically don't order until after the parties have mediated, and if that's unsuccessful, then we look at case evaluation if both parties are willing to go through that process. So that's how we'll go forward with regard to ADR. I will set this for a status conference at the close of discovery. So by that point, the parties should have mediated the case and gone through discovery. If we don't have a resolution, then at that status conference, we can talk about case eval. If that's something that the parties want to engage in. We can look at further scheduling at that point, and then set some deadlines for any further dispositive motion cutoffs and so forth. So this would give us just kind of a basic framework for the parties to get started to go through mediation and then see where we need to go from there. Mr. Martone, do you have any objection for that as a way to go forward?
No objections, Your Honor. I think that makes a lot of sense.
Mr. Traskos?
No objections.
Okay. So I will put all of that into a pretrial order that'll go out to the both of you. Also, notice of the date and time for that status conference, which will be by Zoom like we're doing today. And that's all I have for today. You're both free to disconnect. Thank you.
Thank you, Your Honor.
Okay, I need to grab that sign. Take a short break. Okay, we're on the record in People versus Mallory Stefan, case number 245348. The record should reflect Ms. Stefan's present here in the courtroom. If I could have counsel take your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Stefan.
Thank you. This is a continuation of a sentencing hearing from last month. Ms. Stefan, are you going to participate in this hearing today?
Yeah.
Okay. All right. I'm not sure how far we got last time, Mr. Trush. Have you been able to go through the pre-sentence report with Ms. Stefan?
She reviewed it in court last time. We talked about it prior to that.
Okay. Did you need to speak with her at all today?
I don't believe so.
Okay. Ms. Stefan, do you need to go through anything about that report with your attorney today?
I didn't get to finish going through it because I got pulled aside.
Okay. You need a minute to look through it?
I already noticed that some of the things in there were true.
Okay. What things weren't true in there? Let me start by asking you this. How about like information about your prior history and your prior convictions and those kind of things? Do you think any of those things are correct? Okay, which of those do you think is correct?
Joseph Gilner.
Huh?
The one with Joseph Gilner.
Okay, that's that might be 5 of 7.
I believe that to be accurate.
Okay. So that indicates the charges, the things you were charged with, and how that case was resolved. What's incorrect about information?
When
I'm sorry, did you say nothing?
when I finally got out of that situation, I tried to come back and I tried to say something. I tried to reach out and speak up about what happened. Because
Well, let me just, we're not going to argue about whether things happened or didn't happen. What I'm talking about is just the information about the charges and the conviction and the dates and those kind of things. I know you don't want to agree with what happened in that case, but this isn't about that. This is about the information in this report. Is that correct?
Okay. I don't understand what you're asking then.
So I don't want to argue about the facts of what happened in that case with Mr. Gildner. I'm asking you if the dates in the report that show when things happened and what the charges were, and how those charges was resolved, if you have some dispute about the factual information.
I didn't solve.
Okay, again, I'm not gonna, it's not what this is about. All right, I'm satisfied that the prior criminal history for Ms. Stefan is correct. Ms. Stefan, you don't agree with what's written in terms of the.
I was never punching or kicking her.
Okay.
I was being drugged around by my hair and tackled to the ground, being called a bitch and a whore.
Okay.
When I got up and I called the police.
Okay. Mr. Trush, are you aware of any factual information contained within the report? I understand that Ms. Stefan contests what's in the police report and what's reflected, and she doesn't agree with that information. But are you aware of any factual information in the report that's not correct?
So I guess what I would indicate is I think she does have an ability to obviously give her version of events when she has the ability to allocate. In terms of things that I would indicate to the court that are incorrect, one, obviously the jail credit needs to be updated. It's currently at 3 days. I think the probation department actually agrees with me that 20 is the right number, or I should say I've done my math right this time. Correct, Judge. In addition to that, they list that there's one prior felony conviction. It's probably splitting hairs. I think that's factually inaccurate. The felony conviction occurred after this. So again, it's probably splitting hairs, but I don't think it's properly called prior.
Okay, Mr. McDowell.
I guess, yeah, I don't have an objection.
Okay.
I guess I understand what he's saying. Usually you just put the record down, right? I didn't, there's no scoring anyways, but obviously I wouldn't have scored it if this was a felony, but.
Okay.
Could change it to 0.
All right. Any other corrections, Mr. Trush?
No, Your
Honor. Okay. Ms. Cope, do you have any victims that wish to address the board today?
She is present. I do not think she wants to speak.
Okay. Ma'am, can you just tell me your name for the record?
My name is Mary.
Oh, thank you. I just want to make sure I know who you are. Ms. Koch, anything that you would like to say for allocation?
You know, I was looking at my notes for Ms. Stefan, and I actually went back to my last case with her. And it says Judge Mertz sentenced the defendant. He gave her 5 days in jail and held 25 days in abeyance. Thinks she should work on her CMH and her recovery. And we talked about those issues in that case. Ms. Stefan has a really hard time acknowledging the things that she does wrong, and has a tendency to always blame the other person. It's been that way in every case I've had with her. You know, she's not very old. She does have some, from what I can tell from her records, some mental health history, whether she wants to address it. Her attitude towards Mr. McFalda is, you know, I'll come up there if I can. I don't need these things. So I really don't know the answer if she doesn't want to work on the problems. I mean, she entered a plea. It was difficult. The court was there. You know, she changes her mind. We were headed all set for trial. I honestly think it was a great idea for her to take a plea, because I think the likelihood of conviction was high, and she would have had a significantly higher recommendation if she had been convicted as charged, or at least in the principal charges. I've tried to give her some breaks in the past. She even got a pretty good break in this case. I really don't know what to do with her. I think the recommendation is appropriate. I don't think she's necessarily a very good candidate for probation. Thank you.
So, Your Honor, I think there are several important things to consider here. You know, at first blush, I look at the recommendation here, and it seems strange to me. We have a recommendation that's essentially asking the court for a straight jail sentence on a person who has only had 1 prior probationary sentence and successfully completed it. Not only successfully completed it, was discharged early from probation. So from that standpoint, the recommendation seems kind of strange. Now, I certainly can understand why that recommendation may be made. I also think it's important to recognize Ms. Stefan struggles with the court stuff. And I say that, you know, we spend all day in court, right? For me to stand in front of the judge and speak and to address some of these issues is not a big deal. I do it all the time. I understand how to do it, understand what to say, what not to say. I think what we see from her when she gets into court is a trauma response. And I don't know where the trauma is. I don't know the answer to that. But it's not normal, right? It's not normal to be in court and be asked a direct question and not be able to answer it. And again, I don't know what the answer is, but it's certainly not something that we typically see. I tend to agree with Ms. Koch, where I think there's probably some mental health things going on there. Because again, we process plenty of cases, and in the vast majority of those, the defendant is able to articulate, right? Whether they articulate they want a trial, whether they articulate they want a plea, or even in the scenarios where it's difficult. Because I recognize that, you know, we say, oh, you want to tender a plea or you want to go to trial, and that's probably not really the right way to phrase it in either scenario. I don't know that I've had many clients who want to come in and tender a plea or want to go to a trial, but those are the choices they have. I think what we see from Ms. Stefan is when she's faced with those choices, essentially 2 bad choices, right? Two things that are not good for her. She freezes and she can't cope with it. She can't react. And then we see the inappropriate behaviors arise from there. I say all that to the court because at one level, it would make perfect sense to place her on a term of probation. She's been successful at that in the past. At the same time, I can certainly understand that on its face, it would appear that placing her on probation may be setting her up to fail. There's, instability with her ability to get up to the court to report, and she identified that. Again, did she identify it in the way that I would have wanted her to say it? No, but I think she identified that. So, I really don't know what to suggest to the court here in terms of how to handle it. I could see a straight jail sentence and could see benefits to Ms. Stefan from that type of sentence. I also, from sort of the raw facts here, could see a primarily probation-based sentence. I would suggest to the court in any event that I do agree with the prosecutor. I hope Ms. Stefan pursues counseling through CMH or some other avenue. Because again, I don't think the behavior that we're seeing at times is normal responses. Thank you.
Thank you. Ms. Stefan, anything that you wanted to say there?
I already said something. I didn't punch and kick her hair. I did start with an argument and I started packing my stuff to leave. And she was sitting outside on the porch and I was standing in the door behind her talking to her. She got mad, she got up, she grabbed me by the top of my head. She threw me on the ground outside, jumped on top of me and started screaming about how I was a bitch and I was a whore. Started making accusations to me against my cousin. So we kind of laid there in the grass for a while until somebody showed up and hosed us down with a hose to get us to separate. I didn't have her hair in my hand, she had my hair. And after that, I got up and I went in the house and I locked all the doors and kept myself inside until I could figure out what to do. I called several people, including her boyfriend, because he was the only other person that lived there that I knew who to call. And he was taking too long to get home from work, and that's when I ended up calling the cops. But I was not punching and kicking her. We did get into an argument over something because that was the second time I went to the police that day over an incident. And it wasn't even the first time that week that she had put her hands on me. Earlier in the week, she was drunk and she was screaming at me about all sorts of things in the middle of the night for at least 3 hours. This wasn't the first time that it happened, and that's when I ended up calling.
Okay. All right, well, I read through the report. I've listened to what you had to say here, what the lawyers had to say. I'm familiar with you and your circumstances. You've been in front of me before. Separate assaultive matter. The thing that I have a hard time with, it seems based on your behavior that there's some mental health issues here going on. But it's hard for me to tell how much of that and how much of your actions are caused by mental health issues, including your behavior in court, and how much of it is just you denying responsibility for things, you acting out and then wanting to blame.
I'm not denying responsibility. I wouldn't have called the police if I didn't need help with something.
Well, you just denied responsibility here for everything. And you're continuing to deny responsibility for past incidents that you're convicted of.
That weren't true.
And I don't know how much of that is attributable to some kind of mental health issues again, and how much of it is attributable to you just wanting to live in your own world and pretend that the things you do didn't actually happen. And how much you want to try and play games with the court to see how long you can drag things out and continue to avoid responsibility. And maybe it's some combination of those two things put together. I can tell you this, that you've amassed a record of assaultive offenses, both here and in other jurisdictions.
Which were dismissed.
You've been sentenced to 45 days in jail one time, 90 days in jail another time.
I've never spent 45 days in jail.
And so in my view, we need to have progressive penalties. I don't think probation is the right thing for you. I agree with Mr. Truce, generally somebody with this record, probation might be appropriate, but given that you're engaging in assaultive offenses, given your behavior in court, given your behavior while on probation the last time, even if you did successfully complete it, I think the longer you go, the less probation is going to be a good option for you, and it's likely, as was said here, going to set you up for failure. So I think what you can expect if you continue to engage in assaultive behavior is more and more jail time, and eventually you're going to find yourself.
I don't have the right to defend myself, and I don't have the right to call the police because I get in trouble
So
for calling the
what I'm
police.
going to sentence you to
When I'm
here,
assaulted.
which I think is a fair sentence, is 6 months in the Crawford County Jail. You have credit for 20 days served. Court is going to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $160 state costs. You do have the ability to seek an appeal of this sentence. Because this is a misdemeanor, there are no written appellate rights. If you wanted to file for an appeal, you would have to do that within the next 21 days. If you have more questions about that, Mr. True should be able to help you with that. Ms. Koch, is there anything further we need to address for the record today?
No, thank you.
Mr. True?
No, Your Honor, thank you.
Ms. Stefan, you are remanded to the custody of the county at this time. That is